May I please, Your Lordship? Lordship, I beg to mention item number 37, Your Lordship. Lordship, that matter pending before the Salsa, Your Lordship. And the date has been fixed on 18 August. So,
What do you want?
another date.
Why?
Because before the Salsa, this matter has been pending and date is fixed.
Use your mic.
Yes, Your Lordship.
Yes, what is it?
Lordship, the Salsa short document regarding medical report, Your Lordship, we have already received and submitted before the Salsa, but there is a small confusion. There is a small confusion before the Salsa member that there is a mention only PS case number, but the name of the PS has been not mentioned in the medical report. That is a confusion and member short for clarification from the medical officer.
Mr. S.I. Akandal, counsel appearing on behalf of the petitioner, seeks for an accommodation. This matter again on Durat na ki dekhai na pa. Ai boshoto yat theke bole no. This matter again on 25th of September 2026.
Deeply.
Deeply obliged. I am for the respondent number 2, Lordship, in the item number 37. Obliged.
Okay, Your Lordship. Lordship, I beg to mention for the item number 30, Lordship. Lordship, Mr. R. Professor is holding this brief, Lordship, and he is not well, Lordship.
Who?
Mr. R. Borpuzari. We are led by Mr. R. Borpuzari. Due to some health issues, he could not be appear before your Lordship. So adjournment for the day, Lordship.
On the ground that standing counsel of the revenue department is not well. The matter stands adjourned to be listed again on 18th of September.
Lordship, I am appearing for the petitioner, Lordship. There is an interim order that should be continued, Lordship.
The interim order passed earlier shall continue till the next sign.
Obliged, Lordship.
If I may, my lord, I beg to mention a WPC for listing, my lord. A writ petition for listing, my lord.
Not here.
Duty of it.
May it pleases your lordship, I would beg to mention item number 4. With the consent of the other sides, your honor, the conducting counsel is out of station due to some health issues. So
See when the matter reaches.
there is an interim order, your honor. Interim may be
We will
continued.
see when the matter reaches. Have you heard it? And Mr. Kyle, while taking up this matter, item number 43 at 2 p.m., you are not there.
Not sir.
But the state finance department is there.
Not sir.
I'd like to hear you on something.
Not sir.
Why is it kept here? Very difficult. You're correct. Yes, what is
May
this?
it please, Your Lordship, as per the office note dated 4th of August, the service report is awaited, Your Lordship. On respondent number 2.
What is the order passed?
4th of August,
Please,
Your Lordship, the 7th of August 2000, sorry, 27th of May, the order was passed to take steps upon the respondent number 2 because it is a content petition and we had to implement.
Which order you are seeking?
The impugned order dated page 29, Your Lordship. The impugned order. 20 June 2024, the order was passed. Your Lordship, my case is that, Your Lordship,
What was the direction passed in the earlier judgment?
Your Lordship, my contention was that the order was passed without any jurisdiction by the concerned authorities, because as per section 2B of the Land Sealing Act, I was exempted. So, Your Lordship, pursuant to that, the order was passed to take into consideration my grievance. And Your Lordship, if you may kindly turn to annexure B, that is at page number 19. I had approached this honorable court whereby
Only the earlier order.
first order is at page number 19, Your Lordship. The writ petition, I had approached this honorable court by writ petition number 4995/2005. And thereafter, Your Lordship, that is page number 26. Again, I had approached this honorable court by writ petition number 4958 of 2018
What order was passed?
to consider my grievance of the fact that Your Lordship, I may just, Your Lordship, the contention was that as per section 2B of Assam Fixation of Ceiling or Landholdings Act, the government did not have any jurisdiction because I was under the I was an exempted unit. But thereafter, the order was passed and I was allowed.
So the order dated 16/7/2004. Yes, government. 16/7/2004,
Yes, Your Lordship.
by which you were permitted to retain 212 bighas, 3 kata, 8 lachas,
Yes, Your Lordship.
was interfered with by the judgment passed in
7 March 2013.
7th March 2013.
Yes, Your Lordship.
And the matter was remanded back to the collector and the deputy commissioner for a fresh decision upon hearing the parties.
Yes, Your Lordship.
Thereupon, nothing happened, I suppose.
No, no action was taken on their part. And
So
therefore,
therefore,
again,
there was a direction again passed at page 28
27th of July.
that the present petitioner has submitted the certified copy of the order along with the presentation. Shall dispose of the representation as per the direction of the order dated so and so within a period of 3 months from the date of receipt of the order. Then another round of litigation
Yes, Your Lordship.
for not taking steps to press decision in land ceiling case.
Yes, Your Lordship.
Now, that has not been also complied with.
Not been complied. I was called for a meeting, and a hearing had taken place on 15th of July 2024. Pursuant to that, they
Now, within 3 months,
within 3 months, no,
that has not happened.
not happened.
So, thereafter, you have again requested them and the deputy commissioner have not done it.
No.
Now, Mr. Isami, you see what has happened here. A sealing case was initiated against the petitioner. Petitioner's cases, the sealing case could not have been initiated against the petitioner. Then an order was passed whereby at that point of time allowing the petitioner to retain 200 bighas. Then there was a direction to again look into it by the court. That was in sometime in 1990, 82 or 85. This matter went to writ appeal and all whatever in 95 or something went to writ appeal. Now thereupon what has happened in this case is an order was passed on 16/7/2012.
24. 24.
No, no. 16/7/2012. 2004. Now this is very important. 16/7/2004 stating that the petitioner can retain 212 bighas. Now, that order was passed. That order was set aside on two grounds. One, the petitioner was not granted an opportunity, and the second, the jurisdictional question have not been decided. Now, thereupon, what has happened? That order was not complied with, for which another writ petition was filed. The second writ petition. The second writ petition said that again, that within 2 months or 3 months you do it. That was again not done. Then comes the third writ petition, wherein he says the court directed that in terms with the 2013 order and 2016 or 17 order, comply within 3 months. That has not been done. So here it is. Now the question which is happening out here is, if the order of 16/7/2004 have been set aside, government's final statement is that the final statement on which the land has been taken by the government has gone.
Yes.
Without that order, you cannot attain it. That order has to be there. So why is the government not taking a decision on this aspect? It's a very serious aspect. Because tomorrow, we are concerned this has happened from 1968, this litigation.
Yes.
So let the deputy commissioner apprise this court why he is not doing it. Because without that order, government cannot. Mr. P. Nayak, you see what has happened is this particular T state or whatever this petitioner, you see, as per the Assam Fixation of Land Ceiling Act, certain lands have gone on ceiling, certain lands have been allowed for the petitioner to retain. That was challenged here initially in 1992. Initially in respect to a proceedings of 76. The said writ petition was not interfering with that order, directed the collector to look into it on the question of jurisdiction. Thereupon, the collector passed an order on 16/7/2004, stating that the petitioner is entitled to retain not 200, 212 bighas. Now, once that order is being passed, meaning thereby there is no finality to the final statement. Thereupon, he challenges this order of 16/7/2004. That was set aside by a judgment passed in the year 2013, directing to again look into it. Meaning thereby asking the petitioner to retain 212 bighas or whatever may be, the final statement is being touched into. Thereupon, what has happened in the year, again the petitioner filed a writ petition saying that the order has not been complied with. When that has been mentioned, the court directed again to look into it and pass an order. That was not complied, which led to the third writ petition, wherein directing them to comply in terms of the 2013 and 2015, the Deputy Commissioner have not done it. One thing is that as regards non-compliance of that order is another aspect. But the most pertinent aspect is there is no finality to the sealing proceedings. So take it up with the Deputy Commissioner as to, without there being a finality to the selling proceedings, what does that happen in respect to the land will go haywire. You may be giving some land, you can't allot it also because that order has been gone to for a 6. So I'll ask you to take it up with the Deputy Commissioner why this has happened. Once it is being taken note of, let the Deputy Commissioner deal with it and pass an order, whatever may be. But there has to be a finality to the 7(6) provision of Section 7 by which the final statement is passed, so that whether the petitioner retains this amount or that amount or whatever may be, or whether he retreats the order of 16/7/2004, we are already 22 years down the line, that these are things which needs to be adjudicated and finished. So I think this needs to be brought to a conclusion. So we ask you, not him, but I'll request you to take it up with the Deputy Commissioner as to what has happened. He will give you a copy of the petition. You take it up.
Yes, Lord.
The present application has been filed alleging willful and deliberate violation to the order dated 26/2024, passed in WPC number 1154/2021. It is relevant to take note of that the present proceedings is an outcome of a long is an outcome of various judicial proceedings. For the sake of convenience, this court finds it relevant to take note of that the petitioner company, it's a company, na?
Yes, Your Lord.
The petitioner company, which is a government of India undertaking, in the year 1959, purchased 3 grants from one Radhika Nanda Chaudhary, comprising of 1249.941 acres of land. The said land was mutated in the name of the petitioner. In the year 1963, a sealing case was initiated against Radhika Nanda Chaudhary, which was disposed of in the year 1967, allowing the company to retain an area of 586 bighas plus 150 bighas as retainable land. The petitioner thereupon filed a writ petition being Civil Rule number 309/1968. And the same was disposed of by setting aside the impugned order. Setting aside the order. And directions were issued to the collector to dispose of the matter in accordance with law. The petitioner company was then taken over as per the provisions of the Sikh Textile Undertaking Act 1972 and subsequently acquired under the provisions of the Sikh Textile Undertaking Nationalization Act 1974 with effect from 1/4/1974. It was the case of the petitioner that the provisions of the Assam Fixation of Land Sealing Act of Sealing on Landholding Act 1956 was not applicable to the petitioner company. Be that as it may, in the year 1976, another land sealing case was initiated, wherein the petitioner raised the question of jurisdiction for initiation of such proceedings under the Act of 1956. Be that as it may, by an order dated 29/6/1992, the government of Assam in the Revenue Department set aside and quashed all orders passed in LC case number 364/76 and directed the who is the respondent number 3 therein? No idea. Directed the respondent number 3 in WPC number 4995/2005 to proceed de novo with the matter. It is also said that the respondent number 2 in WPC number 4995/2005 allowed the petitioner company to retain 200 bighas of land till the disposal of the said case. Being aggrieved, the petitioner filed a writ petition, which was registered and numbered as Civil Rule number 2758/1992. The said writ petition was disposed of without interfering with the order by which the petitioner company was allowed to retain 200 bighas of land till the disposal of the sealing case. However, this court directed the collector would look into the jurisdictional issue as well in the said proceedings. Being aggrieved, a writ appeal was filed, which was registered and numbered as WA number 610/1996. However, the said writ appeal was dismissed. Next. The collector, Kamrup Metro, by an order dated 16/7/2004, disposed of LC case number 364/76, whereby the petitioner company was allowed to retain only 212 bighas, 0 kata 8 lechas of land. The petitioner, being aggrieved on the ground that the said decision was taken by the collector, Kamrup Metro, without giving the petitioner an opportunity of hearing and also without deciding the jurisdictional question, filed a writ petition before this court, which was registered and numbered as WPC number 4995/2005. The said writ petition was disposed of by the judgment and order dated 7/3/2013, whereby the order dated 16/7/2004, by which the Lance LC case number 364/76 was disposed of, was interfered. And there was a specific direction issued to the collector, Kamrup Metro, to decide afresh by giving a hearing to all the parties. The records further reveal that there was no decision taken in LC case number 364/76 after the order dated 16/7/2004 was set aside. Resultantly, the petitioner was constrained to again approach this court by filing a writ petition in the year 2018, which was registered and numbered as WPC number 4958/2018. The learned coordinate bench by an order dated 27/7/2018 disposed of the said writ petition with a direction to the collector oblique the deputy commissioner, collector Kamrup Metro oblique the deputy commissioner Kamrup Metro to dispose of the representation as per the directions so passed in the order dated 7/3/2013 within a period of 3 months from the date of receipt of the certified copy. The record further reveals that in spite of that, there was no action taken on the part of the deputy commissioner, Kamrup Metro, which led to the filing of the another writ petition by the petitioner, which was registered and numbered as WPC number 1154/2021. The learned coordinate bench by then another order dated 26/2024 reiterated the directions and again directed the respondent number directed the deputy commissioner and collector Kamrup Metro to complete the exercise in terms with the orders passed by this court in dated 7/3/2013 in WPC number 4995/2005 and the order dated 27/7/2018 in WPC number 4958/2018 within a period of 3 months from the date fixed for hearing, that is 15/7/2024. It is the case of the petitioner that pursuant thereto, there has been no disposal of the representation as well as the disposal of the land ceiling case. And it is under such circumstances, the petitioner is before this court by initiating the present contempt proceedings. This court have given an anxious consideration to the materials on record. And from the materials on record, it transpires that in view of the setting aside of the order dated 16/7/2004 by the learned coordinate bench in the judgment and order dated 7/3/2013 in WPC number 4995/2005, the land ceiling case being LC number 364/1976 still remains undecided. It is the opinion of this court that without a finality being reached in land ceiling case number 364/76, further steps cannot be taken by the state in respect to the land which was acquired on account of being beyond the ceiling limit. First, there is also no finality as to how much land the petitioner can hold. Taking into account the seriousness of the matter, this court therefore have requested Mr. P. Nayak, the learned Additional Advocate General, to obtain instructions from the Deputy Commissioner Kamrup Metro as to why the orders, the judgment and order dated so and so, 2013 or 24, as well as the judgment and as well as the other two orders dated so and so and so and so, passed in WPC number so and so and so and so respectively, have not been complied with. In addition to that, the learned Additional Advocate General shall also obtain instructions from the District Commissioner Kamrup Metro as regards the finality pertaining to LC case number 364/1976, inasmuch as the order dated 16/7/2004, which was passed, have already been set aside. A copy of the writ petition of the contempt application be served upon Mr. P. Nayak, the learned Additional Advocate General, during the course of the day. The registry shall also provide a copy of this order so that to Mr. P. Nayak, the learned Additional Advocate General, so that he can so that the needful can be done. First, list this matter again on.
Lordship, may I pray for 4 weeks time? Lordship?
That is what I'm fixing.
Lordship, immediately I am going to have a discussion with the.
On 2nd of September.
Lordship.
List the matter again on 2nd of September 2026. The registry shall show the name of Mr. P. Nayak, the learned Additional Advocate General, in the cause list. It is not a question of contempt, but the question is, if you don't have the finality, now there might be some people who are there.
Yes, Lord.
You can't grant the patta because there is no acquisition. Acquisition by that act can only happen when there is the final statement and the final order has been set aside. So something has to be brought to an rest. Whether they get this amount or not, that is another thing. They were only to be heard, nothing more.
Yes, Lordship.
Deeply obliged.
Cooperator will be-
What happened?
May it please your lordship.
Yes.
Your lordship, we have duly taken the steps upon the respondent number 5, your lordship.
Service is complete.
Yes, your.
What is your matter?
Your lordship, the matter pertains to eviction.
So, you've been evicted. What is there left?
Your lordship,
You want the land back.
yes, sir.
It's not possible.
Your lordship, as my senior is out of station, kindly grant 1 week of time.
Yes, you file your affidavit. Doesn't it? Why you have done it?
Page 67, Lordship.
Huh?
Page 67, Lordship. There's an impin order, Lordship.
Please,
67, Lordship.
please use your mic. There's a mic there, na?
Page 67, Lordship.
What is this?
This is the impin order, Lordship.
Your eviction was when?
2017.
Seven.
Huh?
2017.
And you approached this court in
It is
2025.
the second round of litigation, your lordship.
What?
Second
What
round of-
happened in the earlier one?
Earlier round of litigation, your lordship, The impugned order has been brought on record on 10/3/25. And
Appears from the order that this court had directed. the
in
adjudicator
several
to
10
grant this
occasions,
regard
the
status
order of this
matter
honorable court.
filed by for settlement. But it appears from here that though some instruction was given by the receiving man, be that as it may, since the matter pertains to Iraq, acquit the respondent without fail shall apply this court. Further make clear the AI so and to be man also in terms of here. And what happened to this?
Your Lordship, this honorable court has on 10 several occasions directed the respondent to apprise the honorable court on the
What
status
happened in
of
the
the
earlier round of litigation?
That is what I'm trying to convey, Your
pending.
Lordship. The status of the proposal made by the petitioner society for allotment of the subject plot in its favor. The court has specifically directed the respondents to apprise this matter, Your Lordship. Your Lordship may come to page numbers.
No, it has been given to some North Lakhimpur.
Municipal.
Yes, Your Lordship, but
So what right do you have?
the
You have been
impugned,
evicted or not?
yes, Your Lord.
Then what it means? What do you want back?
Your Lordship, the impugned order has not been brought on up record for last 4 years, Your Lordship. And the last, on the date of 10/3/25, the impugned order has brought on record, Your
Set
Lordship.
aside the order as to why I read.
Before that, Your Lordship, there are 10 occasions of this honorable court.
What right you have directing the respondent to restore the possession of the petition? Not possible. That case. You have been evicted in 2017.
Your Lordship.
And who are you? Tell me, who are you?
Satyam Seva Committee. Your
What?
Lordship.
Registered society.
Organization of
society.
AI. Are you registered?
Yes, Your Lordship.
Where is your registration?
Registration page number 27, Your Lordship.
You registered just in the year, yeah. What happened thereafter
And where?
when you filed the writ petition? This was only valid till 2019.
That instruction I have not got. Your Lordship.
Then no longer registered. And why you are not filing an affidavit?
Some instruction we have received, Lordship. Some instruction I have received, Lordship.
You cannot receive the instruction of 2025 now.
In several 10 occasions, Your Lordship, the
What
honorable
happened to the?
earlier round of litigation, just
What happened to that? Has it been disposed of?
disposal with the liberty to file afresh, Your Lordship. We have
Where is that order?
order, Your Lordship, page number 94, Your Lordship.
Page?
Page number 94, Your Lordship.
But your liberty is for what?
To file afresh, Lordship.
For what?
Your Lordship, just,
File afresh is okay.
yes,
But your cause of action which was there,
yes,
you have already said it to become infructuous.
yes, Your Lordship.
You see, there cannot be both. If it is infructuous, you cannot have a liberty. Your claims have to be saved. This type of writ petition not permissible.
Your Lordship may kindly grant 1 week of time, Your Lordship, as my senior is out of station, Your Lordship.
It is seen that though notice was issued on 4/6/2025, the respondents have not brought on record their affidavit, their stand. Mr. N. Goswami submits that the affidavit would be filed, that the government would like to, the state would like to file the affidavit. Accordingly, a final opportunity is granted to the state to bring on record its stand by filing the affidavits on or before 16th of September 2026. Is the matter on 25th of September 2026 for admission.
File afresh, Your Lordship.
Please, Your Lordship. Well, in this case, the respondent number 7, my lord, we took service, my lord, of notice on him, my lord, on the address in the work order. That has come back unserved. He is the, my lord, contractor, my lord, who was assigned this job. My lord, we may be allowed to take the steps to the, my lord, department because that's the only address we have. And it's as per the work order, we had taken the notice. Served the notice, madam. Mascom builders. It's road is being widened, my lord, over the land.
Why you making the respond number 7 a party?
Lord, because he was given the work on order, my lord, that's the
What
reason.
are you asking for?
Nothing against him, nothing against, my lord, compensation, my lord, for that.
So then how does respond number 7 has
Since
any
we-
relevance?
Well, since he was given the work order, therefore, my lord, as a proper party, my lord, we had next.
Are you asking for setting aside the
No,
work
no.
order? No. Your basic case is your land has been taken by the
Yes.
PWD without following the due process. That's it.
Madam,
Why do we need the respond number 7? And who are respond number 8 and 9?
Respond number 8 and 9, my lord, are, my lord, the relatives of the petitioner, my lord, who were not, had not come to this court, my lord, as petitioners, my lord. That's why we made parties. Brothers and.
So your land has been taken.
Yes, my lord.
And what is your stand?
But we have filed on affidavit, Lordship.
You file affidavit.
Yes, Lordship.
They've
Well,
Lord, admitted that the
Admitted.
road has been widened, my lord.
Yes.
What does the affidavit say? Where is your affidavit?
We have filed it on 19/2/2026.
Quote of the letter. Yes, PWD. From this report, it is clear that you are using somebody else's land. The report as annexure 1 to the affidavit filed by the respondent number 4.
Report to court.
Bring your record, bring your affidavit on
Lordship.
record. We don't require 7.
My lord, man.
Unnecessary, don't make this 7. The grievance of the petitioner in the present proceeding is that the respondents in the PWD have constructed a road over the petitioner's land without acquiring the rights over the land. Mr. M. Dr. Dolan, Senior Counsel, appearing on behalf of the petitioner, drawing the attention of this court to the affidavit filed by the respondent number 6 and the annexure 1 to the said affidavit, submits that even the revenue authority accepts this aspect. This court also takes note of that the presence of the respondent number 7, who was a contractor, is not necessary for the purpose of the present case, inasmuch as the construction has already been completed. Na?
No, my lord. There's an interim order, my lord, regarding status. It was being, my lord.
Yeah, you got an interim order.
Yes, there's status quo order. It did not reach
It's
our
not
land.
necessary, taking into account that the respondent number, the petitioner is not seeking any relief against the respondent number 7. This court also takes note of that by an order dated 17/12/2025, there is a interim order passed by this court to the effect that the status quo as regard to the possession of the land in question shall be maintained. The interim order thereupon have been extended from time to time. But this interim order is not going to help you out. He is in possession.
Well, what has happened before the road did not reach our land, it was below, the neighboring places, Malad, it had reached. So therefore, the status quo order was granted, protecting Malad at that point of time, Malad.
So you are not, the land has not.
That has not been taken, Malad. That is not.
Then,
Because, Malad,
then why did you file the requisition?
because, Malad, the land.
And why is it mentioned that over that land this is
Because
going
the
on?
widening process they had initiated, Malad, and it would encroach our land.
No, no, this affidavit, kindly see, if that be so,
Malad.
why this is being mentioned, this report? Annex 1.
Yes, Malad.
Mr. Nayak, kindly see this. If that is so, that is goes against it. The road from Nagaon to Hathabari is running over Dag number 138.
Yes, but some.
In fact,
persons
Malad,
are- if lordship
the
comes to
road
the-
was running in from our land initially. All along, it has been running from our land. Now the extension is taking away further land, Malad. Original road is also running through our land, Malad. We have not raised an objection to that. But the extension that is being done now is encroaching further land of ours, Malad. That's why we are before lordship.
Lordship, if some clarifications is required, I think Lordship, if Lordship comes to page 53, Lordship paragraph 4.
Yeah.
Lordship, this map was prepared only in the year 1963, Lordship. And some dots mentioned in the map which indicate the actual road on the ground has originally there over many decades now.
That's okay.
Yes.
So my question is,
In paragraph 10, we have specifically stated, Milord, the existing road was also in our land. Now further, Milord, extension, Milord, is encroaching out further land. That's in paragraph 10, we have specifically stated.
but they have not.
They because the construction.
But how do you know about they are going to encroach?
Because, Milord, the line that was being, Milord, the road, the way it was being extended, Milord, so it would encroach into our land, Milord, if it continues through our land, Milord. The proposed map, Lordship will find, Milord, at page 47. So there is an extension, Milord, on side, both sides there.
Page
Page 47, Milord. The diagram, Milord. Both sides they're extending the road, Milord. Earlier, Milord, the clear way was, Milord, 5,500. That is being extended to 7,000, Milord. Then there is, Milord, earthen shoulders on both sides. Then, Milord, drains are being constructed. So this will encroach our further land, Milord. That's the case.
Heard Mr. M. Dotto, the learned counsel appearing on senior counsel, assisted by so and so appearing on behalf of the petitioner. Mr. P. Nair, the learned additional advocate general who appears on behalf of the PWD department. Mr. N. Gusami, who appears on behalf of the revenue, the district administration of Borpeta. Petitioners herein are aggrieved by the steps taken by the PWD authorities for broadening the Nagaon Hathabari road,
Existing road, yes.
broadening,
Yes.
whereby as per the demarcation carried out, certain portions of the petitioner's land would be encroached.
Right.
It is the case of the petitioner that till date, the construction, there has been no encroachment. Mr. M. Dotto submits that learned senior counsel had submitted that if there is any encroachment upon the petitioner's land, the same can only be done so after following the due process. It is seen from the affidavit filed by, it is seen from the records that this court, while issuing notice in the year 2000, issuing notice on in that this court, while issuing this court, by an order dated 17/12/2025, directed maintenance of the status quo with regard to the possession of the land. Full stop. Subsequent thereto, on 28/1/2026, notice was issued, and the interim order thereupon have been directed to continue. Full stop. The records reveal that an affidavit had been filed by the respondent number 6, wherein the respondent 6, wherein a report of the circle officer, whatever revenue circle, have been enclosed. In the said report, it is mentioned that Mr. Counsel, I am surprised. Writ petition filed in November 2025, and you enclose a report of July 2025. How is it possible? You knew that they are going to file a case. Writ petition was filed on 27/11/2025, and this report is of 24/7/2025. Isn't it surprising, Mr. Nayak?
Yes, and in fact, the
That
representation.
means this circle officer knew that they are going to file the year after 4 months.
We had filed representations, well, perhaps that is a.
Understood. So when this court has issued notice, you should, it is your duty to give an updated status. What notice has given? Wherein they have enclosed the report of the circle officer, Hottebury Revenue Circle, as Annexure 1.
And in fact, the representation
It
is
is,
also.
it is surprising to take note of that the Annexure 1 to the said affidavit filed by the respondent number 6 is dated 24/7/2025, whereas the writ petition was filed on 27/11/2025. Full stop. It is always expected from the district administration, when notices are issued, to give a proper and an updated status, and not a status which did not arise at the time, even prior to the filing of the writ petition. This court therefore directs the respondent number 6 to file a fresh writ petition, to file a fresh affidavit, detailing it out as to whether any land of the petitioner is going to be encroached, while widening the road, the Nagaon Hottebury Road. Full stop. The PWD is also directed to bring on record their stand as to whether any steps have been taken for acquisition of those portions of land, more particularly belonging to the petitioners, before taking any steps for going ahead with the widening of the road. First, Next, this court also finds it relevant to take note of that the respondent number 7's presence is not essential in respect to the subject matter of the present proceedings. Accordingly, the respondent number 7 the name of the respondent number 7 is struck off. Full stop. The interim order which was passed earlier shall stand continued till the next date. When are you filing it?
2 weeks, Lordship.
You file it because there is a stay, so obviously we need to finish it off. List this matter again on 26th of August 2026. In the meantime, the affidavit on behalf of the respondents, so directed herein above, be brought on record by 19th of August 2026 for admission. Yes, what is this?
May it pleases your lordship. The conducting counsel, your lordship, is out of station due to some health issues.
Who are you?
I'm for the respondent number 2 and 3, Lordship.
Who is
CGST.
respondent number 2 and 3?
So, Commissioner of GST, Lordship. CGST, Lordship.
And what is this? Another
GST, my lord, 6 and 7.
order in original past?
By central GST, my lord.
Huh?
Central GST, Your Honor. CGST.
Order in original has been passed.
By CGST, Lordship.
Look, finding at page number 25, my lord.
I'm not inclined to extend the interim order. Do whatever you feel like. You need it after 1 year, 2 years, that's your lookout. You
Your
cover
lord-
the entire amount from them.
Lordship, only one recommendation
No,
may be given.
it is, you know it very well. This court is very harsh on this. If there is an interim order, if you have a good case, I would allow it. But this is not a case. First of all, you have not challenged the order in original here. Why should we stay it? Not possible. Never heard of. Where is Mr. Kyle?
Lordship, my senior is in Lex in court number 1, Lordship. Matter is going on, Lordship, there.
How can we look into all these things? Absolutely no. Never heard of. Sorry, I can't interview.
Lordship, only 1 day accommodation may be given, Lordship. Only 1 day accommodation may be given, Lordship.
Yes, Mr. Kyle. What type of orders are being passed?
Lordship.
First of all, there is a challenge to a notice passed in.
Yes, Lordship, in 22.
Notice issued what? This is a 74-5 notice.
11, page 48.
The writ petition,
Yes, Lordship.
page.
Page 48.
Yes, notice for intimated discrepancy in the area. This is not a 74-5.
No, Lordship.
This is under 61. Then
And Lordship, interim order was passed.
reply. Then your notice issued under 61. Then
Page 55.
this is a notice issued under
This was Nisur
74.
74.
Please refer to the proceedings under year under year with reference to the Iman so and so available under so and so. April to Iman, so and so Iman, so and so Iman, 73 lakhs. The grounds and quantification are attached here. So this is a 74-5.
Yes.
Then
Lordship, probably their main contention was that state as well as the central has in state proceeding as them. Probably this is the case, but this is the case of the petitioner that both the central and state is at the same time initiate the proceeding.
Ah.
Probably, but in the writ petition that is not reflected. Lordship.
no. Who has passed that order? The final order.
Final order passed by the central Lordship.
And
Page-
this notice which was issued, which is Annexure 3, is by whom?
One by the central GST and another by state GST.
By the Assistant Commissioner of State Tax.
Lordship.
So when you say that when they have issued this notice of 1/4/2022, that is their case, you could not have initiated under that, under sections,
Probably
this is,
that was their contention.
but is there a bar?
No, Lordship. After, till the investigation, both the
Investigation in respect to section 6.
Lordship.
Then,
Probably that was their case, probably, and Lordship in 2026, final order has been passed by the central GST. That is, they have challenged that by filing this case, Lordship.
no.
That
You
cannot-
cannot challenge like this.
Yes, Lordship.
No, you cannot, one cannot challenge like that.
Yes, Lordship. This is my contention, Lordship.
No.
In intellectual application 1709.
No, it can't be possible.
Page 25.
We do one thing. We extend it only for 1 day. And if your senior doesn't comes out there, we dismiss it. In fact, your writ petition has become infructuous.
Yes,
In view of the passing of the other order, your writ petition has become infructuous because there is no challenge to their initiation by them. By way of a miscase, you cannot improve your case in that. Having heard the learned counsels appearing on behalf of the parties, this court is of the opinion that the matter can be finally disposed of. This court fixes this matter on 11th August 2026 at 2 p.m. for final disposal. The interim order so passed in IAC number 1709/2026 stands extended till the next date
Obliged.
at your request, but your petition is misconceived. What is this?
For infringement of the Reserve Bank of India.
Implement of Reserve Bank. Oh, this
Fund
one.
Bazaar.
Okay. And allow for replay, file your memo of parties within 7 days. You are appearing, anybody appearing for Reserve Bank? No. I mean, so, nearly, issue notice এইটো ইখনত notice issue কৰি দিব returnable on so and so on 23rd September. Steps be taken by speed post.
I will take the
ইখনত
steps,
এইটো order সেইটো ইখনত order.
but I will take the steps within 3 days. Lordship.
Fix it on so. Huh? Are you disposed or is money? Yes, what is this?
Your Lordship, my bank account was frozen
Hi, who?
by HDFC Bank on 8/8/2022. Notice was sent on 22/6.
What happened to you have service not complete? Which account? HDFC. You have not been able to serve.
Your Lordship, through speed
Oh, 15/7 notice has been issued. What can I do? Why don't you approach the GRM? Go there. Because there immediately it will be taken. I'll put it out there. The grievance of the petitioner herein, heard so and so wording. Of the petitioner herein that his current bank account bearing number 502 Saita 0 2123 Tinta 0 426 33031 maintained in the HDFC Bank Limited at Mongoldoy branch was frozen on 8/8/2022 by the bank authorities without any notice. This code duly takes note of the SOP এখনৰ নামটো আছে নহয় আমাৰ এখন SOP এখনৰ নাম আছে আমি order pass takes note of this so and so issued by the Ministry of Home. Wherein there is a grievance redressal mechanism set up for redressal of grievances of the present kind. The petitioner, in the opinion of this court, that the petitioner herein would be well advised to approach the branch manager of the petitioner's bank.
Your Lordship, this may not be applicable in this case because
Right.
this case was not registered in NCRP. So there's no acknowledgement number as such. This is an
Oh, you
offline
go and inform them. You don't have anything. You see, the problem lies this. This has been done from 2022.
22.
You have come here.
Yes.
Service has not been done. So if you don't go there, you are not satisfied. Then how do you are not going to get a relief?
Actually, sir, this SOP is just for NCRP portal complaints,
What?
which have an acknowledgement number. But this
No, you approach them by filing a petition. And approach them. That is what I was passing. And then they will pass that order. No, I'm directing them to look into that and then put it out there. Because here you have to approach the branch manager. Once the branch manager will turn and then act as per the standard operating procedure and take the needful. Otherwise, to lift the freeze. I'm giving you a relief. You don't want that. Well, approach the branch manager of the respondent, shall approach the respondent number 2. The respondent number 2 shall along with shall approach the respondent number 2 along with his or her
He's
he
he.
his complaint and a certified copy of the present order. And the respondent number 2 thereupon shall take effective steps in terms with the SOP procedure so and so, so and so. So that the grievance of the petitioner is duly taken note of, is duly considered. Within the time frame mentioned in the SOP.
Seven, eight, nine. Their names were corrected yesterday, Lordship.
Huh?
Yesterday it was corrected. Included in the Jamabandi copy, their name.
What? Their names have been included. Matter over.
Matter.
Mr. Purkasta. You got the relief even without saying anything. All are three different petitioners.
Yes.
Have been corrected in DAG number 735 of KP Pata number 110
Yes.
of village Saukasi.
Yes.
Where is that order?
Lordship, in the backside it is not readable, but the Jama
Oh.
corrected. Lord.
Your names have been inserted. এই তিনিখন রিট পিটিশনত নহয় সব বেলেগ বেলেগ নাম Are you all related?
Yes.
No, no,
What?
Yes.
no, no,
No. Are these
purchase,
three
individual-
persons not related?
no. Individual purchaser,
Huh?
individual purchaser.
Lordship,
They are, my lord, purchase the land separately.
এই বাকি দুখন ফাইল দিয়কচোন
Individual purchase. He depends on it. He denies.
এই পিছনেরটা শেয়ার করতে হবে।
Now 2 and 3 these two persons are same. This item number Dimple Patwari is the daughter
Yes.
And Tulu
and
Patwari.
Tulu Patwari is the wife. What? Mr. Purkasta.
Lordship is the correction of order.
Dimple
That
Patwari.
order was there, Lord.
Daughter of Satyanath Patwari.
And both are same. One is wife and daughter. You have forgotten your mother.
Sorry. And they purchase the land by.
Because the house, both are residing in house number 2A. One is 2 and 2A.
I'm sorry much. I did not even open the brief and moment I got the instruction.
এখন এখনকে বেলেগ বেলেগ কৰিব। We'll pass separate orders.
Yes, yes.
Heard Mr. A.K. Purkasta, the learned counsel appearing on behalf of the petitioner. Mr. S.S. Roy appears on behalf of the district administration.
2, 3, and 4.
On item 7. The present petition has been filed by the petitioner, being aggrieved by the
Impugn order 1712.
No,
No, sorry, order dated by in not complying the order dated 1712.
24.
24. Inaction on the part of the.
Mr. Purkasta, you stop writing this small case so long.
This prepared by him,
Huh?
prepared by him.
Then also he has been, you have taught him also. It's a small matter, you have drafted it for 48 pages. File the instant writ petition. Being aggrieved by the inaction on the part of the respondent number 4 in refusing to make necessary correction of the revenue records and restore the name of the petitioner in the record of rights in respect to the land measuring 1 katha 10 lechas covered by DAG number 417 old /735 new of KP Patna number 1110 situated at Revenue Village, Swakosi under Moza Beltola in the district of Kamrup Metro, Assam. It is also the case of the petitioner that the name of the private respondent number 5 should be removed in view of the order dated 17/12/2024 passed by the respondent number 2 in Miss number 299/2023. Pursuant to the filing of the instant writ petition, this court had issued notice on 24/6/2026. Mr. S.S. Roy, the learned junior government advocate, appearing on behalf of the district commissioner, appearing on district administration, submitted that necessary correction of records have been carried out as per the prayer made in the writ petition. In that regard, he has placed before this court an instruction of the circle officer dated 6/8/2026, as well as the updated record of rights, which are kept on record, which is kept on record and marked with the letter X. Taking into account the above, nothing further remains in the instant proceedings for which the writ petition stands disposed of. Stands closed. এইখনত X খনক দুখন X বনাব আৰু ফটো এইখনৰ আৰু দুটা ফটো কৰি এইখন এখন হ'ব আৰু দুখন ইয়াত লগাই পেলাই এইটো তিনিটা ডিসপোজ হ'ব। Yes.
Me, please, your lordship. Lordship, this proceeding is against the inaction of respondent number 2 and 3, DC office and Bakijai officer, for not proceeding as per the Bengal Recovery Act. Recovery or certificate was issued by RERA for compensation and refund. 1 year already lapsed. And as per the office note, last office note, the notices are duly served.
Lordship, in This two part of money lordship, two part of compensation. In one, we have sent the notice lordship. He has received the notice, but she did not appear lordship. And in second lordship, we have written a letter to the RERA seeking some original copy of lordship requisition certificate lordship.
How many proceedings are there?
Lordship, there are two proceedings. One was for compensation and one was for the refund of the principal amount along with the interest. So the one in which it was for the refund of the principal amount, when we inquired in the Bakija office, they are saying that they don't have the file. So we also approached RERA. They said they haven't received any information from the Bakija office. So there is a contradiction between the Bakija officer's information to the petitioner and what the RERA had informed us verbally. And in the other, that was for refund. After we filed a writ petition, a date was fixed. This writ petition was filed on 23rd June, and notices were issued on that particular date. On 30th June, a date was fixed for the appearance of the respondent, private respondent, that is the builder. On that particular date, they appeared, but we asked for a copy of what they had furnished, and also we inquired about the next date of the
Mr.
hearing.
Goswami, is that the same case? This is a different one.
No, judgment letter is the same.
Yes, judgment.
Payment is different.
Judgment paper is same.
Yes, builder is the same. I have entered my appearance today, madam. This morning I have filed the income correspondence. I'll obtain this. But the direction is.
No, there is nothing for us to do out here. It's for the Bakija officer to do it. Why the Bakija officer has not taken any action?
Notice issued to them lordship. Notice issued in one compensation amount. Notice has been issued lordship. But
And what about the other?
we have seeking some original documents from the RERA lordship that we have perhaps not received lordship.
What do you require? You are going to decide.
Oh, no, original copy lordship.
Of
Original copy
before
of the
issuance
requisition.
of notice.
No, for of the requisition of the certificate of public demand form 2 lordship. From
You
RERA.
issued a letter
Lordship.
to RERA.
Yes.
Lordship, we approached RERA that Bakija officer had told us that they had sent the file back to RERA for some clarification, and they are saying that they haven't received any kind of letter from the Bakija office to the extent what the Learned Council is submitting. And after that, for the other proceeding, when the date was fixed for 30th, now when we approach to ask the subsequent date of the hearing, they are not even giving us the date. They are saying that since you have filed the writ petition, you take the remedy from the court. They're not even giving us the second date of the hearing.
Here he is appearing. So, Mr. Goswami, we fix a date on which you appear in that proceedings before RERA. And the second is, you have issued the communication to RERA.
Lordship, I have the
You have a copy of
Yes,
it.
lordship.
So give that copy to her,
They have
so that
received.
she can very well take it up with them or
Lordship.
the RERA.
Lordship,
Mm.
RERA is also a party to this
So
proceeding.
what?
We have made
You
a.
take it up with RERA. You see, it is not for anything, you filed it well.
Sir, Lordship, the recovery certificate was issued on on March 2024, 2025. More than 1 year.
Then,
They're not doing anything.
who?
Bakijai or the RERA, we have approached both of them, Lordship. More than 1 year, RERA is saying we haven't received a copy. They are saying we have not got a recovery certificate from them. And the private respondent is well aware about the proceedings that is taking place in Bakijai. In a similar matter also, after the writ petition was filed, the allotee got the remedy. I have that IA number also along with me.
Now, this recovery certificate is for how much? 10 lakhs.
One was for 10 lakhs and the other was for 66 lakhs
Where is
50
the
lakhs.
other one?
We haven't received it from RERA.
Well,
We just have the
why
order of
should we
RERA.
take it up with all these things? If you have not got it, obviously, Pakistan can't they do anything on that?
They are saying us that they have sent the file to Bakijai officer. If your lordship finds the order
Is
in
it
page
the
number,
duty of the court under Article 226 to do all these things?
lordship, after 1.5 year of the proceeding, if the RERA is saying they haven't received any information, Bakijai is not cooperating with us. So the decree is just remaining on the paper as of date. And now after writ petition is filed, they're even refusing to give us the next date of the proceeding, lordship.
What is the next date? RERA is being represented by anybody? RERA issues the certificate.
RERA issued the certificate.
That certificate you can't take certified copy.
Lordship, we can apply for a certified copy. It is generally sent directly to the Bakijai office.
Understood.
Yeah, we'll meanwhile apply for the certified copy as well so that we have a copy.
And on the basis of the certified copy, proceed with the Bakida. Yes. If the RERA is not representing before this court, service is complete as regards RERA.
Yes, Lordship. 4, 5, and 6 as per the office note.
6 is he representing.
Yes.
Yes, ma'am. Proceed.
There is only one writ petition,
There is only one writ.
this one.
Yes.
From the office note dated 3/8/2026, it is seen that the service is complete in so far as the respond number 4, 5, and 6 are concerned. The B.D. Goswami, the learned counsel, appears on behalf of the respondent number 6. The grievance of the petitioner herein is that in pursuance to 2 orders passed by the respondent number 4
And 5.
in respect to the order dated 5/11/2024 passed by the respondent number 4 and with the other order.
The other order is in page number 41.
Both are by the same. Orders passed by the respondent number 4.
One is by the adjudicating officer and the other is by Real Estate Regulatory Authority. Judgment passed by adjudicating officer, RERA Assam.
In pursuance to the, it is the case of the petitioner that in pursuance to the order dated 14/12/2023 passed by the member Real Estate Regulatory Authority Assam, as well as the judgment dated 5/11/2024 by the adjudicating authority of the respondent number 4. Two proceedings have been initiated. Two certificates have been issued to the Bakijai officer of the Dispur Co-District Commissioner, Kamrup Metropolitan, the learned counsel for the petitioner has submitted that in one proceedings, though notice have been issued, but no action thereupon have been taken. And in the other proceedings, the Bakija officer, that is the respondent number 3,
Yes.
have sought for certain informations from the respondent number 4 and 5. The petitioner, upon making inquiry before the respondent number 4 and 5, they have informed the petitioner that the Bakija certificate, that the Bakija certificate have already been issued to the respondent number 3. It is the grievance of the petitioner that by one way or the other, the respondent number 3, 4, and 5 are not taking effective steps so that the order dated so and so, 14/12 it was, as well as the judgment dated so and so, are brought to the logical conclusion. Ms. So and so, the learned counsel who appears on behalf of the petitioner, further submitted that on account of filing of the writ petition, the Bakija of the respondent number 3 has informed the petitioner that in view of the filing of the writ petition, they are not even providing the next date of the proceedings. An updated status in that regard be placed by Mr. N. Gusami as regards the proceedings pertaining to, in respect to both the proceedings pending before the respondent number 3 on the next date. List this matter on 28th of August 2026 for admission.
March August.
Maybe please, Lordship, Argo Council suffering favor, Lordship. Kindly second half or
What?
Argo Council's suffering favor, Lordship. Kindly second half or date, Lordship. Dusty notice served to the respondent number 5, Lordship, but denied to receive. In this regard, we have to submit our affidavit, Lordship.
How is it possible, this type of orders? If it is unsafe, how can we decide as to whether it is safe? Who are you? Who are you?
I am S.A. Mandal, on behalf of
Petitioner.
Who are you?
petitioner,
You are a
Lordship.
tenant.
Petitioner, Lordship.
Tenant.
Yes, yes, tenant.
Tenant of whom?
Tenant of respond number earlier 7 and now it's 6.
Who?
But earlier he was tenant, but presently that house is vacant, Your Lordship. But I am placing that photograph of that house. It's not a position to now. Only the adjacent building belongs to the petitioner.
Huh?
The adjacent building,
Put the mic properly.
the adjacent building, I have given the photograph, belongs to the petitioner and he's running this business, but he's trying to get the land. This is
Which is the house?
the old building, Your Lordship. The
Ah.
tree above that,
It is vacant.
presently vacant.
Whose house it is?
That belongs to respond number 6. Respond number 6, Your Lordship.
His house,
Lordship.
not the petitioner's.
Not
Petitioner is a tenant
tenant. Earlier he was tenant
of the respond number 6.
7, because 7 is the father of the 6, Your Lordship. After partition, respond number 6 purchased the said plot of land from his cousin and uncle, Your Lordship. And adjacent building, it belongs to the blue color building, multiple story building belongs to the.
So it is a landlord tenant dispute between so and so and so and so.
Lordship. Lordship.
And what is the suit filed by them?
Suit filed by against respond number 7 and this husband, not against the 6.
Huh?
Suit filed by them. 2 suits they have filed. First suit filed, Your Lordship, against the 115/2025. It is against the respond number 7, not against the 6.
Now the room is not occupied by anybody.
There are some materials is there, they have not vacant, Your Lordship. I tried to vacate, requested him vacate the.
Who are you?
I am the owner of the land. Respond number 6.
So there is a suit now being pending filed by the petitioner.
Petitioner against respond number 7.
Maybe,
Right.
but he must have in the meantime substituted. That's a different thing. But that suit is pending.
Pending.
Is there any injunction there?
No, no.
No injunction.
No.
Where is the impugn order annexure C?
Page 73, Your Lordship.
Page?
Page 73, Your Lordship. After joint verification by the expert, Your Lordship, they said that PWD and municipality, that house is not safe.
Now, why is the Dhubri Municipal Board acting on in respect to a private property
Because I have filed a petition
regarding
for take necessary step
or
for demolishing this building, Your Lordship.
so that
They have, after inquiry, they found that it is.
how is it possible? You, instead of filing a suit for eviction, have now resorted to doing asking the Dhubri Municipal Board to do on your behalf. How is it possible? The Dhubri Municipal Board has no business. You file a suit for eviction, that's your lookout. But all the other things, how will the petition? You cannot, by way of involving the Dhubri Municipal Board, has no business.
Some one day, Your Lordship, some portion is already fall down, Your Lordship, collapse. Building, then it is unsafe for the petitioners because they are residing in nearby house, Your Lordship.
But there is an injunction also. See that order at page 73. You are saying there is no injunction. You are not using the building. But you claim that you are a tenant
Yes, Lordship.
and not to be evicted without due process. That's your case.
Yes, Lordship.
No, we state it's an absolute case of a high-handedness on the part of the Dhubri Municipal Board in taking action on the basis of a suit which you should have filed for eviction.
I'll file affidavit. Already stated.
Understood, but I think we should set aside this order. This type of order cannot remain because the Dhubri Municipal Board has no business to do all these things. You file a suit for eviction. If it is unsafe, the Dhubri Municipal Board, can they act out there and say that, okay, don't use it? What is the power of the Dhubri Municipal Board? Do they have the power to say that don't use it? Show me the power under the Municipal Act by which they can stop somebody.
No, they are not saying that it's, they say the demolish, no, yeah, not unsafe, they say. Municipal says.
Can they pass that order? Under the Assam Municipal Act, can they pass that order? Now you are appearing for whom?
I'm
6
for
and 7.
6 and 7.
Who is 6 and 7? 7 is alive.
Alive, yes.
Is the husband.
No, yeah, father, yes.
Heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner. Mr. N. Gusami appears on behalf of the respondent number 1, 2, 3, 4, 3. Who appears for 3 and 5? Mr. S. Islam appears for respondent number 6 and 7. The petitioner herein has approached this court challenging the action on the part of the respondent number 4 and 5 in taking steps for demolition of the building wherein the petitioner claims to be the tenant. This court duly takes note of that there is a suit filed by the petitioner being title suit number 66/2026. How many suits have you filed?
Two
Mr. Counsel?
2 suits. One is 11725. It is against respondent number 7. And another is
Where's the first suit? Is it on record?
it's not on record.
Huh?
It's in the copy.
It is an updated case from the material as could be seen from the materials on record. That the petitioner is a tenant of the respondent number 7.
Plus, 7.
In respect to the building which is sought to be demolished, by the respondent number 4 and 5. The said action on the part of the respondent number 4 and 5 is based upon a complaint submitted by the respondent number 6, who is claims to be the present owner of the building in question. There are two suits which are pending before the competent civil courts filed by the petitioner. That is title suit number 117/2025 as well as title suit number 66/2026. The court inquired with the learned counsel appearing on behalf of the petitioner as to whether the petitioner is presently using the said house which is sought to be demolished. The learned counsel submits that the said house is not being presently used for carrying on the business, but certain materials are stored inside the house. From the materials on record, so it is seen that the respondents are yet to bring on record their stand by filing the affidavits. However, from the materials on record, it prima facie appears that the respondent number 6, who claims to be the owner, have instead of resorting to filing a suit for eviction of the petitioner, have taken steps before the respondent number 4 and 5 for demolition of the building. Thereby rendering the very tenancy infructuous. It is therefore the opinion of this court that the interim order which was passed earlier is required to be extended on 2/7/2026 is required to be extended till the final disposal of the petition. Accordingly, the interim order passed on so and so stands extended till the final disposal of the petition. The respondents herein are granted the liberty to bring on record their stand by filing the affidavits on or before 23rd of September 2026. List the matter on 30th of September 2026. The pendency of the writ petition shall not bar the respondent number 6 to initiate any civil proceedings if so advised. What is this? What has happened?
I am for the respondent number 1 to 4.
Ah, yes.
Freezing of account.
Why you have put is under freeze?
Lordship, in this case, what happened? Petitioners were requested to file the original certified copy. He has submitted one photocopy of that order, Lordship.
You want the certified copy, then you will give it.
Certified true original copy.
Of?
That was not of the arbitral award, Lordship. That was not submitted, and that cannot be authenticated, and only for that reason the account cannot be defreezed, Lordship.
Now,
If
isn't
your
there
Lordship-
an order passed by the arbitrator? to
Arbitrator,
end
yes.
that?
Yes. That was the Annexer B, Lordship.
Ah.
Annexer B, the photocopy was submitted to the bank.
Page
Which
one?
one?
Page
Page
14.
14, Lordship.
Page 14.
14. The
You want the certified copy?
Yes, Lordship, for authentication, the original certificate copy, Lordship.
And on what basis did you initially freeze the account?
Order dated, Lordship, here in this order, it is clearly stated, Lordship. Interim order dated 23/5/2025, Lordship.
Huh?
Interim order dated 23/5/2025, Lordship, of that arbitral tribunal, Lordship.
Where is that order?
That order is not here, Lordship, but in the
How
Annexer
did you,
2,
how
Lordship,
did you get that order?
that was submitted.
How? How did you get that order?
Lordship, I can.
See, you want this order, the certified copy, then only you are going to vacate. Now, you have a copy of the,
No, original copy I don't have, Your Honor.
why?
I have been served with this only. I have to procure from the arbitrator.
How is it possible you don't have it?
I don't have.
Can there be an arbitral award without the original copy
No, I
being
have not-
served upon you?
I have not been procured. I have not.
Then why you are approaching this court? Have you informed him about that document, that requirement of that document?
Yes, Lordship, verbally, verbally we have requested him.
Written.
And written, Lordship, we have sent
Why
email,
did you ask
email
him?
to,
Huh?
send email to the respondent number.
Where is your
5
instructions?
also.
Could you,
Lordship, only telephonic instruction.
we'll take it up at 2, get your instructions. Written instructions to the effect that if this particular document is given, you are going to release it, unfreeze it.
Lordship, if you, Lordship,
2 o'clock, otherwise pay compensation of 10,000 rupees per day till Monday. 2 o'clock. You knew about this thing. On the last occasion, I made it very clear when the adjournments were sought for. I made it clear, this matter cannot remain.
Lordship, which direction
2
to
o'clock,
much of it.
produce that instruction, because on the basis of just verbally saying, I can't. Produce the instruction at 2 o'clock.
Lordship.
What is this?
May pleasure, Lordship.
Stay vacating of what?
Lordship, of the order dated 9. Of the
What
order,
is the matter about?
Lordship, the matter pertains to Lordship. If your Lordship kindly comes to page 36 of the IA. A provisional land mutation information was issued, Lordship.
We are challenging the order dated 13/11/2025 being allowed by the Assam Board of Revenue without notice to you.
Lordship, that is challenged by my learned friend's client, Lordship. I am for the respondents in the writ petition, Lordship. I have filed the IA for stay vacating.
Why?
Lordship, the order which was passed, if your Lordship kindly comes, the page 36
Of your
of the IA, Lordship, stay vacating interlocutory.
page?
Page 36, Lordship.
Yes.
Page 36, your Lordship will see it is of 7th February 2024, provisional land mutation information. Now, Lordship, this we had challenged before this honorable court, your Lordship's order, page 37. The relevant, your Lordship will find at page 39, wherein your Lordship had clarified that this is not a mutation order, but is merely a provisional land mutation information. Page 39, Lordship.
I've asked you to withdraw.
Lordship, yes.
Then?
Your Lordship has observed that this is not a mutation order. It's only a provisional land mutation information. Accordingly, Lordship, it was withdrawn. Subsequently, Lordship, this 7/2/24 provisional land mutation information was cancelled by the authorities.
Which you had challenged.
Lordship, yes.
What you have challenged
Lordship.
was cancelled.
Cancelled.
Then
Against that cancellation order, Lordship, the writ petitioner appeal before the settlement officer, page 42. Against that cancellation order.
and
Your Lordship will kindly see the prayer in that petition, page 40.
only issue is, I'm
Lordship.
not going to look into. Only issue involved is
Lordship.
whether the Board of Revenue passed the order without hearing, giving the opportunity of hearing to the petitioner.
Lordship, the Board of Revenue took into account the orders.
Where is the Board of Revenue?
Lordship, that your Lordship will find at page 108. Page 103 it starts, Lordship.
Has been passed. Was it passed, giving an opportunity
No.
of hearing?
No.
The matter over.
No, your Lordship will kindly see one aspect. Page 100 to the
Let the Board of Revenue hear him and pass an order.
Lordship, the Board of Revenue Board of Revenue did not go into the merits. Board of Revenue only stated that since this order, because this Honorable High Court had clarified that it's only a mutation information, and therefore the settlement officer treating the same to be mutation certificate is not correct. Therefore, without going into the merits, it was only remanded back to the settlement officer to hear both parties and then take a decision. That was the only direction. And accordingly, the impugned order of set aside of the settlement officer, wherein this information was treated to be mutation certificate, that is at page 102.
What was challenged by you?
Lordship, page 101 order, Lordship, passed by the settlement officer.
Against the order dated 4/7/2000 passed by the settlement officer so and so.
Page 100.
The learned settlement officer set aside the order dated so and so of the Eastern Settlement and upheld the provisional land mutation information dated.
Lordship, the settlement officer treats this mutation information as a mutation certificate, which is what we were aggrieved by.
Yes.
Wait, please, Your Lordship. My lord, will kindly come to page number 36 once of the IA.
Yes.
My lord, this is a provisional land mutation information that was issued in favor of the school. And the purpose for issuance, Your Lordship will find it page 11, for permission and registration of the school only. Now, this is something that the applicants or the applicant herein is averse to. My lord, this is the same matter or the matter connected there to today listed at as item number 28, where one of the uh, person in collusion has challenged the credentials of the headmaster of this very school because of that OBC and NCL certificate, which is also today listed before this honorable court. Now, my lord, the crux of the matter here is this land information, provisional land mutation information was cancelled on 5/12/2024 by respondent number 4 without giving us any opportunity. That order by which this land mutation information was cancelled. Before that, they approached before.
Who has cancelled it?
This was cancelled by respondent number 4 of the writ petition, that is the assistant settlement officer.
But I did not interfere.
No,
with that.
no, your lordship did not interfere, but they cancelled it, and they cancelled it without even hearing us. Now, against that, we preferred the appeal before the concerned authority, that is Miss
Who has
Appeal 1,
cancelled? Who has cancelled it? Respond number 4.
assistant settlement officer,
Who is the respond number 4?
assistant settlement officer.
He cancelled it.
He cancelled it. Now, against this
Against
order,
that, you filed an appeal to the
Settlement
the settlement officer, in terms of section 147 of the Assam Land and Revenue Regulation, and in that appeal, after hearing both the sides, order dated 4/7/2025 was passed. Your lordship will kindly take page
No,
number
it's
100.
okay. He has passed an order.
Yes, and
Then-
in that order, all the aspects were taken note of,
Understood. Then
and the provisional land information was upheld as it was found to be only for the purpose of obtaining registration and prior recognition of the school.
thereupon,
Thereafter, they approached the Board of Revenue in appeal. In the appeal, without issuing notice to us, without even admitting the appeal, the order has been interfered with and by the Board of Revenue. That
Who?
is by the Board of Revenue, my lord. That is the
how
order.
many judges
My lord, it has been passed by the chairman, who is also.
alone?
Yes, hello.
So isn't it an appellate order of the settlement officer being put to challenge before the Board of Revenue?
Yes, the appellate order of the settlement officer
Is challenged
was
before the
challenged
Board
by
of-
them before the Board of Revenue.
You
And
have the Assam Board of Revenue
I have it, my
regulations?
lord. I have it. In this, my lord, the provision under section 149.
I'm not asking about 149.
My-
I'm asking you, do you have the Assam Board of Revenue Regulations 1963 with you?
Oh, no. That regulation I don't have, my lord. I have the Assam Land and Revenue
Hey, don't
Regulation.
get up on the reason. Mr. Chakraborty, this is unfortunate. You come before the court not prepared or didn't bring the document,
My lord, which document, my lord?
this act.
My lord, that
Regulation?
Assam Board of Revenue Regulation, that, my lord, but I'm on the Assam Land and Revenue Regulation, my lord, 149,
Assam Board of Revenue Regulations.
my lord.
See, Regulation 45.
Classes of cases to be heard by benches. Classes under the following acts will be disposed of by the benches constituted by the chairman from time to time in the following manner. Insofar as this Assam Land and Revenue Regulation is concerned, it is an appeal and to be heard by single bench. Well, this is what is provided as per.
Whom?
Oh, insofar as yes, single.
What?
Single. Oh, my lord, insofar as
You
appeal
don't
under
know how
section
what you are doing
147.
it.
My lord, section 147 appeal
Appeal against original order single bench, appeal against
Appellate
appeal
order
against division bench.
Division bench.
So this order which has been passed by the Board of Revenue is
Otherwise
without
also
jurisdiction.
jurisdiction, my lord.
How do you take care of that?
This aspect.
Huh? We do one thing.
Lordship.
We vacate that order
Lordship.
because Mr. D. Chakraborty is not prepared.
Lordship.
He comes before the court not being prepared. So therefore, we vacate that order, let him suffer for some time. Then we'll see.
My lord, I was on a different track, my lord. Your lordship.
Your track is different.
My lord, I was on natural justice track, my lord.
What natural justice? Natural justice, you also, this court can also, you bring in the question of natural justice.
My lord.
Now let us apply Aligarh Muslim University.
My lord, that is there, my lord.
A doctrine of useless formality comes into the picture. This is what he has said. Look here, he has not looked into all these things. All these things have not been looked into. So therefore, and there is also the issue of natural justice which he has taken before the Assam Board of Revenue. And therefore, if we set it aside, there are two aspects in the Aligarh Muslim University, which are the exceptions. The first exception is a useless formality. That if I set aside this order also and remand it back, it will result in the same order, then it makes no sense. So therefore, if we don't regard 45 and we dismiss your petition on the basis of a useless formality.
My lord, may I respond to this, my lord?
No, you don't respond. You are not prepared.
One opportunity.
No, we vacate.
My lord,
Isn't it? Yes.
my lord,
Prepared counsel has to suffer.
my lord, my lord, submission, if your lordship kindly takes. My lord, insofar as their plea of natural justice, order dated 5/12/2024 was passed in our absence, but in the order dated 4/7/2025 proceeding, they were very much present.
No, there was a remand. There is nothing to the effect. There is a remand
No,
and let the
your
settlement
lordship,
officer again decide it.
my respectful submission is, my lord, Aligarh University.
6 jurisdiction. We can go as
My lord, true. But one thing, my lord, your lordship appreciates whether under section 149 of
You
the
have
Assam.
a fantastic case, Mr. Chakraborty, but you are not prepared.
My
So
lord,
therefore, you have to suffer. The client has to suffer on account of the fault.
My lord, on the jurisdiction part, my lord, I was, my lord, literally oblivious. And my lord, if I'm put
What
to.
do you say, Mr. Botagu? Do you expect a counsel of the standing of Mr. D. Chakraborty to make such mistake? I had considered him in high esteem, but
I'm grateful, my lord.
I would have understood. Okay, Mr. H. Chakraborty may not be knowing it. He's more into service matter. But he is into does a lot of civil matters, revenue matters, and then also he's not aware of that.
My lord, I may be excused for this time around, my lord, because natural justice was the track I was literally holding on to, but this track I had missed out on, my lord. I have missed out on, my lord.
Okay, we allow his petition, remand it back to be decided by the Assam Board of Revenue, giving both the parties an opportunity of hearing. And that has to be done by the division bench. Well, at the end of the day, forget about natural justice. It is a jurisdictional issue. Heard Mr. D. Chakraborty, the learned counsel, appearing on behalf of the petitioner. Mr. H. Chakraborty appears for response number 5 and 6. The present petition has been filed by the petitioner, being aggrieved by the order dated which order?
Page number 130.
2025, passed by the learned Assam Board of Revenue, whereby the order dated 4/7/2025 passed by the settlement officer Kachar, Hailakandi district, Silchar, in Miss Appeal number 1/2025 was set aside.
Mr. D. Chakraborty, the learned counsel appearing on behalf of the petitioner, submitted that the impugn order dated 13/11/2025 cannot withstand the scrutiny of law on two fundamental errors being committed by the learned Assam Board of Revenue. First, in terms with Regulation 45 of the Assam Board of Revenue Regulations 1963, it is the division bench and appeal under section 147 of the Assam Land and Revenue Regulations 1886, for short, the regulations of 1986, can be heard by, has to be heard by the division bench of the learned Assam Board of Revenue. However, in the instant case, the appellate order so passed by the settlement officer in Miss Appeal number so and so, (1/2025), appellate order dated 4/7/2025, passed by the settlement officer dated in Miss Appeal number so and so, was heard only by the chairman. Under such circumstances, the impugn order cannot be sustained in law. Secondly, the learned senior counsel submitted, it is further, the learned senior counsel submitted that the second ground is more astounding, taking into account that an appeal was heard by the learned Assam Board of Revenue and the order was passed, setting aside an order which was passed in favor of the petitioner without even granting an opportunity to the petitioner, which is very much apparent from the records from the impugn order itself. I've also heard Mr. A. Chakraborty, the learned counsel, who appears on behalf of the respondent number 4 and 5, and submitted that a perusal of the impugn order would show that nothing has been decided on merits, and merely the remand was made to the settlement officer for considering afresh, without being influenced by the observations made by the learned Assam Board of Revenue. The learned counsel therefore submits that the question of principles of natural justice violation would only apply when there is a apparent prejudice, and in the instant case, not only no prejudice is caused to the petitioner, but also it would be a case of useless formality for this court to exercise the writ jurisdiction on the ground of the principles of natural justice. Anything more? This court have heard the learned counsels appearing on behalf of the parties and have perused the materials on record. Regulations 45 of the Assam Board of Revenue Regulations 1963 stipulates the classes of cases to be heard by benches. At serial number 10 of the table to regulations 45, it is categorically mentioned that as against an appeal which lies from original orders, the appeal is to be decided by a single bench. And when an appeal is against an appellate order, it is the division bench of the Assam Board of Revenue who has to decide. Taking into account the mandate of regulations 45, the learned chairman of the Assam Board of Revenue could not have set over an appeal, would not have decided singly an appeal which arose out of an appellate order passed by the settlement officer. On this ground alone, the impugned order cannot withstand the scrutiny of law, as the said order was passed without jurisdiction. This court further, let this court now take up the second ground urged by the learned counsel appearing on behalf of the parties, petitioner. This court inquired with the learned counsel appearing on behalf of the respondent number 5 and 6 as to whether any notice was issued upon the petitioner prior to disposal of the said appeal. Mr. A. Chakraborty, the learned counsel appearing on behalf of the respondent number 4 and 5.
5 and 6.
In all fairness, and most fairly submitted that the appeal was disposed of without issuance of notice to the petitioner. This court have also perused the impugned judgment and order, wherein the learned Assam Board of Revenue have drawn conclusions on the merits of the decision of the settlement officer. The conclusions drawn without granting drawn on merits, without granting an opportunity to the petitioner who was a beneficiary of the order dated so and so passed by the settlement officer renders the impugned judgment violative of the principles of natural justice, which is a facet of Article 14 and Article 21 of the Constitution. Accordingly, the incident with petition therefore stands disposed of with the following observations and directions. Impugned order dated so and so passed in appeal number so and so by the learned Assam Board of Revenue is set aside and quashed. Court further, this court directs the learned Assam Board of Revenue to decide afresh the appeal so filed by the by the respondent number 4 and 5, who were the appellants in appeal number so and so. Before by a division bench of the learned Assam Board of Revenue, taking into account certain urgency is being expressed by both the parties. an attempt may be made by the learned Assam Board of Revenue to dispose of the matter within a period of 6 months from the date of appearance of the parties. Next. The parties, the respondent petitioner as well as the respondent number 4 and 5, being present before this court, are directed to appear before the learned Assam Board of Revenue for the further proceedings of the who I either of the parties to the present proceedings are granted the liberty to file a certified copy of the present judgment before the learned Assam Board of Revenue. Basis of the said, the learned chairman of the Assam Board of Revenue shall constitute the division bench. First, taking into account that both the parties are duly represented before this court, they shall appear before the learned Assam Board of Revenue on 9th of September 2026. In the meantime, prior thereto, the division bench be constituted.
Deeply obliged, my lord. My lord, I'm extremely sorry, my lord, for the lack of preparation in
Absolutely.
And one
I
more
hold
thing,
it.
my lord, beg to point.
I have also another book of counsels who do not prepare and come.
One more thing I beg to point out, my lord. Your lordship has mentioned in one part of the order addressing to the counsel for the petitioner as senior. My lord, only 20 years have gone by yet to be conferred, my lord. So that may be corrected. Your lordship has pointed out somewhere senior counsel. So it is yet to come, my lord.
Even without the full court endorsing, I have given.
With this kind of performance, my lord, I am.
Lordship, I am appearing. Lordship, I am appearing for respondent number 5 and 6. It has been recorded as 4 and 5. Obliged.
Deeply obliged.
I have kept the matter today, although I passed that order, but I think I need to dispose it of.
Not.
Mr. Chaudhary, what has happened is this. If you see the particular provisions of section 67, section 67 is the power of inspection, search, seizure, and other consequences. 67(1) refers to inspection. 67(2) says inspection is there, search is there, when it is to the belief of the authority that certain things have been kept secreted. It's a very important aspect, secreted. And then the goods which are there, these goods which are liable for confiscation under 132, those goods you can direct for the purpose of prohibition. The second is, they mention about documents, books, and things. This is subject to seizure. Okay. Now, you see the first proviso says about things which cannot be seized. Then there will be an order of prohibition. Now, if it cannot be seized, maybe certain things cannot be seized, then you will put the prohibition. And what is the scope of prohibition is? You cannot sell or remove. Whereas in the case of search and seizure, you seize it. And the second proviso says, if you seize it, you can retain it as long as it is necessary, otherwise return it. Okay. Now, an interesting thing is there, as I could see from the documents, that this document, that more particularly the INS 02, which is the given under Rule 139(2), this shows that the document, the search was seized, documents were seized, all these exhibits 1 to 135, and the custody was handed over to the petitioner. If the custody was handed over to the petitioner, how do you take care of the proviso to the second proviso to section 67, which says if you don't require it necessary, you return it? How can you keep it under seizure of that document unless you have it? Now, if you see again section 67(5), it says those documents you will give copies. Copies to what extent? Which otherwise would not prejudice the investigation. That's 67(5). And 67(7) says that if within a particular period of time, if you don't issue a notice, then within 6 months, if you don't issue a notice, you are going to return it back. So therefore, the custody of these documents seized has to be with you. The custody cannot be there with the petitioner from whom it is seized. Now, what can be confiscated is another interesting. The confiscated goods are those goods which can be within the purview of an order of prohibition, which is otherwise taxable. Now, can the AC of a chartered accountant, can the refrigerator of the chartered accountant be subject matter of confiscation? Because that is not a question of taxable. Your allegation is he has used this in against 200 firms and given false all these documents, and thereby he has led to faulty claims and all these things. If that is the allegation, for the AC or these laptops or desktops which are there cannot be a subject matter of confiscation. If it is not a subject matter of confiscation, it cannot be an order of seizure or a prohibition. Now, the next aspect, another very important, section 67(4) is you can say it to be a parasite to the powers under section 67(2). When you exercise the power under section 67(2) for search, then only during the period of the search, if a person does not open the door to his premises, you can break open. If the person is not there, he's hiding, but you know there is something goods which are secreted out there, you can seal. But once the period of search is over, can you keep under its seal? Because the seal is always subject to the power of search. It doesn't have an independent power like the GMC has. So therefore, can there be a sealing of a particular provision or of a premises after the search is there? No. So therefore, I think I need to pass that judgment on these lines to that effect. What is the power under section 67(2)? And thereupon, 67(4) is parasitic to 67(2). So once the search is over or seizure is over, search or seizure, because another aspect you see, the moment you are searching, once you have already searched, seizure is being done, order of prohibition is done, nothing remains. Nothing remains. So you can't put that premises under seal under any circumstances. So therefore, that judgment has to consider this aspect. That is why I wanted to hear you on that. Whether this formulation of this appears to be the correct one.
Lordship, correct. This Lordship, whatever Lordship is stated, once search is made, probably thereafter Lordship, the premises cannot be locked.
Yes, Mr. Saraf.
Very aptly interpreted the law, Lordship.
It appears to be so because there are, what is the power? If you see the proviso, the first proviso and second proviso.
Lordship, only when the access is denied to the officers, in that case, a power is given to them that they might break open something where the goods or accounts might be kept. Now, to cover up that exercise, supposedly an officer breaks up the almirah. Now he cannot leave it aside and go away. So for that purpose, the word seal has been used.
No, not for that. Just for example, let's take a house.
Lordship.
Or just for this person's premises.
Lordship.
He is kept under lock and key. He knows, this officer knows that these documents are there. Or all these things are there.
Lordship.
And there is a fear that this person concerned, he's not there, appearing out there, and he may run away if I open it. He doesn't breaks it open. He has the power. He does not. What he does, he seals it till he comes it.
But the access has to be denied. That is primary condition.
So therefore, the access has been denied. So therefore, he seals it.
Yes,
But sometimes, what happens in sometimes that he is there, but he's not opening a particular almirah. So there we use of the words almirah and all.
Yes, yes, Lordship.
So there, what he does, he breaks open. Or even a particular room, he breaks open this power. So this power can be exercised only during the period of search. Once the search is over, that power under 67(4) for sealing or breaking open is gone. Unless there is a fresh initiation of again another search or seizure.
Now there is only two options, Lordship. If after he gets those things, either he can seize it or he can give it to me under order of prohibition. That's it. The two options, Lordship.
Only this. So the order of prohibition, if you see the INS 03, it gives the description of goods. On the other hand, INS 02 says about documents, things and goods. Not goods.
Goods is there.
No. INS 02 doesn't have that. Yeah. Description, books, documents, things.
Okay, goods is not there.
Goods is not there because the goods will be subject matter of confiscation. So there will be therefore INS 03 says goods.
Lordship. Different subject matter.
There are different subject matter. So goods can be confiscated, but books, documents and things can be seized.
That will be required for assessment.
Rule 139, this is section 139(4) says about order issuing provision in what circumstances that has been referred to. And 5 also.
No, therefore, this aspect makes it very clear. So once the search is over, the question of power of seal or the seal or breaking open does not arise. Break open must be preceded by a search, and sealing also has to be preceded, or because the moment you are leaving out, it finishes because it is parasitic to 67(2).
Whatsoever I need, I take it away or I give it to him under an order of prohibition.
And therefore, and another most important thing, many cases you will find the power to give him the jimma is there. But here it is not there. You can't give the jimma to him.
There is no provision as such for jimma.
So therefore, I will pass my judgment out there. I will allow you to take the exhibits 1 to 135 And regarding the other, it's only a prohibition not to remove. You see, order of prohibition says not to remove.
It might be needed to be confiscated.
So he has the right to use it.
But Rule 140, Lordship says about bond and security for release of seized goods. Rule 140 says about bond and security for release of seized goods.
No, this is in terms with section 67(6).
There has to be an application. There has to be an application.
Indemnity and all these things. He may ask for that. Kindly return me the seized goods. Then he has to give us some indemnity to that effect.
Yes,
That is another thing. I'm not on that. But here, that is, he has not done that. So therefore, I will give the department the opportunity to, if you want to keep them, that is your thing. But you can't hand it over to him because he cannot be. And the interesting part out here is this. You seize these documents which are marked as Exhibit 1 to Exhibit 135. You hand it over to him. And the best part is, he is being prohibited the access to the premises where the seized documents where you have given him the custody is there, and you have the custody of it. I mean, what is this meaning of this? Never heard of.
Contrary to the, this is contrary, Lordship, we have never heard this type of.
No, I think this needs to be clarified properly so that later on they do it properly. Otherwise, it would have a. I'll pass the judgment in that.
Recently, what happened, Lordship, the issue came before the Honorable Supreme Court. This issue came before the Supreme Court on 6th of August. Lordship, the ASG submitted that we are ready to open the premises. So matter was disposed of. Nothing has been decided.
No. Therefore, if you see the judgment in Gujarat as well as in Delhi, these were directed to be opened forthwith within 12 hours.
12 to 48 hours.
So within 12 hours, there was a direction, but I will give them the time till 12th, 11th to do it. 11th, they will open everything and give it. And if you want those things, you keep it. Otherwise, you give it back to him, the seizure. Because the second proviso to say is that when it is necessary for you, you can retain it. Otherwise, you have to hand it back. So that you exercise your power if you want it.
Lots.
Disposed.
Lordship, that de-sealing has to be done by 11th, or Lordship will give some other date.
No, I'm passing the judgment. Earlier, therefore I recall that order that they passed an interim order, not necessary. I'll pass the judgment out there. You'll get it by Monday. You will get the judgment. Okay, CV koi Monday di dibi to Monday. I'll pass the order on Monday. I've already dictated the judgment, but I wanted to have a more clarity on that aspect, whether I'm right or wrong.
Much of.
I'll give you time till once I deliver the judgment out there, you'll get the copy. The judgment has been done. You'll get the copy by Monday. You will get the copy. And Monday it is, what is the date of Monday? 10th. Today is 10th, na? By 12th, I'll give you the time to, by 12th to deseal it. Everything has to be done. And then you exercise your powers as to whether to retain or yeah.
Yes.
And these and the others will be under an order of prohibition not to remove, but it cannot stop him from using it. But there cannot be a question of prohibition of AC. Never heard of. Have you ever heard of? No. Because this order has, I have although passed an interim order, but I thought this is of significance because what the GST authorities have done, this is qua charter accountant as well as this may happen to even a lawyer also. A lawyer who advises, a charter accountant advises, because they only advise whatever may be, but tomorrow it will have far-reaching consequences on these professional things. Anyway, chalo. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent numbers 1 to 4. The grievance of the petitioner for which the present writ petition was filed is the continuous action, the continuance of the fees to the petitioner's bank account bearing number 233314540 maintained in the State Bank of India, Meherban Bakpat, Atigaon. In spite of there being a direction from the sole arbitrator in connection with arbitration proceedings number LNT/ARB/LOT-5/45 to remove the said attachment of the bank account. It is the case of the petitioner that on various occasions, communications have been issued to the branch manager of the State Bank of India. However, no action has been taken. The petitioner therefore has approached this court by filing the present writ petition. The record reveals that by an order dated 25/6/2026, this court issued notice with a further observation that pending the next stage, it shall not be a bar on the part of the respondent number 3 and 4 to unfreeze the petitioner's bank account. Today, Mr. G. Sharma,
Yes.
the learned counsel who appears on behalf of the
The
respondent
account is
numbers
not
1 to
freezed.
4.
The account is not freezed. Only a portion of the amount, 30 lakhs, that was hold.
Appearing on behalf of the respondent numbers 1 to 4 had submitted on instructions that the entire account of the petitioner have not been put under, is no longer in an attachment. However, certain amounts in that lying in the account have been, a lien have been kept.
Yes.
The learned counsel further have produced instructions from the respondent number 3, dated 7/8/2026, which is kept on record and marked with the letter X. A perusal of the said instructions reveals that the petitioner on numerous occasions have been asked to produce the certified copy of the order dated 30/7/2025. However, passed by the learned arbitrator. However, the petitioner have not produced the certified copy. It is also mentioned that the other party in the said proceeding, in the arbitration proceedings, that is the L&T Finance, have also been issued communication requesting for the certified original copy of the arbitration order, which have also not been placed before the respondent number 3. Taking into account the said instruction, this court inquired with the learned counsel appearing on behalf of the petitioner as to why the certified copy of the order dated 30/7/2025 have not been submitted to the respondent number 3. The learned counsel submits that the said certified copy or a true copy of the said. You see, you have to also understand. there cannot be a certified copy given by the arbitrator. He has no power. You have to understand that. He have to produce a true copy. Or a true copy of the said order would be submitted to the respondent number 3.
3 and 4, Lordship.
Your Honor,
Branch manager.
Who is respondent number 3?
branch
Chief General Manager, Lordship, branch manager.
Who will respond number 4? To the respondent number 4.
Your Honor, I had a word with the petitioner. He tells me that he had procured this annexure number 2 from the bank itself. This copy has been sent by the arbitrator to the bank itself. But till date, we don't have this original copy of it.
Which one?
The annexure number 2, page 14.
Order, Lordship.
Order.
Where is the arbitrator from?
Arbitrator UP, Uttar Pradesh.
Have you received this document from at page 15?
Lordship.
From L&T Finance, have you received this document?
I have no instruction regarding this, Lordship.
Certified copy of the order. Inquired with the learned counsel appearing on behalf of the petitioner as to why the certified copy of the order dated 37/2025 have not been submitted to the respondent number 4. The learned counsel submitted that that in an arbitration proceedings, but if this is a compromise, you will definitely have an order of this court.
I'm not the party to the arbitration proceeding, but I am one of the directors of Earth Rural Connect Service Limited.
So get it from the Art Rural will have it.
Yes, sir.
Submitted that in an arbitration proceedings, the arbitrator either provides a true copy or the original copy. The petitioner is only a director of the respondents in the said arbitration proceedings. This court have also taken note of the annexure Roman 3 to the writ petition, whereby a communication has been issued by the L&T Finance to the respondent number 4 on 9th of October 2025, wherein it is categorically mentioned that the L&T Finance, that the customer's default with the L&T Finance have been cleared and the loan account have been closed. There is no instructions, however, have been placed by the learned counsel appearing on behalf of the respondent numbers 1 to 4 as to whether the said document was received. Accordingly, it is the opinion of this court that if the petitioner produces a true copy of the order dated 37/2025 before the respondent number 4 and or the document dated the communication dated 9/10/2025 issued to the respondent number 4 by the L&T Finance Limited can be traced out by the respondent number 4. There is no necessity to further keep any lien taking into account the loan account have been closed. Accordingly, the instant writ petition stands disposed of with the following observations and directions. The petitioner, who is the director of the company, namely Art Rural Connect Services Private Limited, shall either produce the original copy of the order dated 37/2025 before the respondent number 4 or a true copy of the said order dated 37/2025 before the respondent number 4. On the basis of the said original/true copy of the order dated 37/2025, the respondent number 4 shall remove the lien in the petitioner's account. Bearing number hekini koi dibo, huh? Number 2. The respondent number 4 is also directed to trace out as to whether the respondent number 4 have received the communication dated 9/10/2025 issued by the L&T Finance Limited to the respondent number 4. In the circumstance the said document could be traced, the respondent number 4 shall also remove the lien from the petitioner's account. With the above, the instant proceedings stands disposed.
My please, Lordship. Lordship, I may be allowed to take fresh step, Lordship.
Why are you not moving under 482 or 582 as per the new BNS? Why are you filing the writ petition?
Lordship.
This is a case for quashing of a criminal complaint.
Yes, Lordship.
Then why 226?
Lordship, this is case is pending in Calcutta, Lordship. Calcutta, Lordship.
Huh?
West Bengal, Lordship.
Then why you are not going to West Bengal?
Lordship.
File it in Calcutta High Court. Why should we look into it?
Three parallel case has been initiated, Lordship, by the respondent number 2, Lordship.
No.
Lordship.
So why should we? Is the case made out or not? Complaint case where?
Complaint case.
Where is the Calcutta one?
Calcutta one is, Lordship.
These are Negotiable Instruments Act.
Yes, Lordship.
So, whereas jurisdiction is not there, is it in respect to the same offense? No. 233 of the Bharatiya so and so has amended this. This is a case under 314. This is not, those are others are negotiable instruments case.
Two are negotiable instrument. Case,
And
Lordship.
where is the other case?
The case is surface on surface Act, Lordship.
What? These are all 138 proceedings.
No, Lordship. Case number, Lordship.
Which case is otherwise?
Annexure, page number 26, Lordship.
Page?
Page number 26, Lordship.
Page?
Page 26.
What is this? This is pre-litigation notice. I'm not on that. My question is, this is surface proceedings done. They have filed a criminal proceedings against you. So, why should we set aside this? No. This is a different, this is 318, 316, 61, 3. What is this? Cognizance have been taken. Go there. Calcutta.
Lordship,
Not
Lordship,
here.
I am appear, Lordship.
Go to Calcutta.
Lordship, I first appear, Lordship, Gauhati, Lordship, at Gauhati, Lordship.
Guwahati is different.
Lordship. At first, I am appear, Lordship, at Gauhati, Lordship. They have initially filed at Gauhati, Lordship.
Huh?
They have initially filed Gauhati, Lordship, at Gauhati.
They should have?
They have initially filed at Gauhati, Lordship.
138.
Yes, Lordship.
138 is different from the other sections. This is 420. Similar to 420. I don't know nowadays what these sections mean. This seems to be 420.
Lordship.
Now 3182 song. Hey, BNS kon dekh samajh ke liye aso. BNNS. Double NS. Aru khan. 318. 318. Cheating. See, 420. Then 316. Criminal breach of trust. Then 61. Criminal conspiracy. So, you have a case for quashing under 406 and 420. There are judgments to the effect that both cannot go together. It's
Yes,
another thing, but not here. Not under 226. Go there. Not this court.
At this
Go there.
stage, Lordship, respondent
Go
make
there in Calcutta, do whatever you feel like. Not here. You see, the case has been made out. A case has been made out. Your question is, should it be filed in Gauhati or there? That's your case.
Yes, Lordship. They have already filed.
For this court doesn't have.
Out of same cause of action, they have.
Oh, this is a different case.
No, Lordship. Out of same cause of action, they have filed, Lordship, at Calcutta, Lordship.
Which one?
Lordship, page number 42, Lordship.
Huh?
42, Lordship. Annexure P3, Lordship. Page number 42, Lordship.
No, in the same cause of action they have filed here where? Which one? In respect to the same cause of action, they have filed it in Assam also.
Initially, they have filed at Gauhati, Lordship, Assam.
Which one?
Yes, Lordship.
This is under 138.
Yeah, 138, Lordship.
138 and 420 same.
One thirty proceeding, Lordship.
Same, same.
Same. No, Lordship.
No. You also know.
Negotiable instrument under
Huh?
138 NI Lordship, they have filed at Gauhati, Lordship, and therefore they have again filed at Kolkata, Lordship.
Understood, but that is on different 420. These sections are for criminal breach of trust and cheating. So that is different. Now another there are many judgments out there to that effect. That once a proceedings under 138 is there cannot be another thing on the same cause of action.
Out of same cause of action, they have, Lordship, same Lordship, agreement number, Lordship. Out of same number, Lordship. The petitioner is appeared, Lordship, at Gauhati, Lordship. Already trial is proceeding, Lordship.
The counsel, you change your pleas in your petition. You have a case. There's no doubt you have a case. But not on that plan. 138 and 420 is different. You have a good case. Therefore, I'm not dismissing it.
At this stage, Lordship, respondent may come, Lordship. Already need to notice was issued, Lordship. So, Lordship, I may be allowed to take step, Lordship.
Why haven't you taken steps?
Again,
Huh?
Lordship, there's some mistake, Lordship, on our part, Lordship. We have
5,000 cost
Lordship,
upon you, not on the petition.
Lordship, inadvertently, Lordship,
No, upon you.
Lordship, actually,
No,
Lordship,
you have money.
Lordship, actually,
No, we
I filed,
impose a
Lordship,
cost
to my
upon
clerk, Lordship. Lordship.
What?
Lordship, actually, Lordship, I have given this file, Lordship, to my clerk, Bijoy Korite, Lordship. He stated he already taken step, but no, Lordship. Yesterday I have.
You
Lordship,
pay 5,000 here.
Lordship,
You take it from your clerk. Huh?
Lordship.
A final of Mr. N. What's your name?
M. Hussain, Lordship.
M. Hussain, the learned, heard Mr. N. Hussain, the learned counsel
Lordship.
appearing on behalf of the petitioner
last chance for
who submits that within 3 days
steps would be taken upon the respondent number 2 by speed post.
Yes, yes,
Accordingly, list this matter on 19th of September 2026. Steps be taken without fail by Monday.
Oblets. I am.
No, as per last one, instruction was sought from the health and nutrition department. Women. My lord,
Who are you? For which
Standing Council
department?
Elementary Education, my lord. Standing Council
There's a
Elementary.
mic.
My lord.
The mic, yes.
Standing Council Elementary Education, my lord.
What is your, why haven't you taken action against?
My lord, that last occasion, this Honorable Court has directed the Director of Elementary Education, but matter pertains to Directorate of Secondary Education, my lord. This under jurisdiction of secondary Directorate of Secondary Education.
You are secondary. Yeah, why haven't you taken action on this?
Actually, we do not have any authority over this issue.
Who?
Secondary Education Department does not have any authority on this issue, and we do not have any objection as well. Yes, Lordship. If the name is changed, if the name of the place is changed, Lordship.
Name of the change from?
From Bhomola Hati to Lansara, Lordship.
From village for the change of the name of the so as well as the IOD from Bhulamati to Lahati Sub-Center, Soilender, Dr. So-and-so, so-and-so, so-and-so to so-and-so, Soilender, Dr. So-and-so. District Commissioner has duly certified that this health center as well as they are at so-and-so. Okay, what does the health department have to say? Health is there?
Yes, ma'am. Yes, Lordship.
What is there?
Lordship, at present, Lordship, the in charge, Lordship, because the director has retired, Lordship. So the in charge has said that, Lordship, since Lordship, it's a decision to be taken by the government, Lordship. So they also do not have such.
What?
Since Lordship, the decision of name change, even if it's allowed, it has to be taken by the cabinet, Lordship. So Lordship, they are not stated anything regarding the.
It has to be taken by the cabinet.
Yes, Lordship. Thereafter, Lordship, a gazette notification will have to be notified.
Why?
For change of name, Lordship.
Of? They are not changing the name of the village.
No.
What they are changing is the name of these institutions.
Yes, Lord.
Wherein it is mentioned as some Bhulamati or Bhulalalmati or something.
Yes,
to Khudra Hazara village. Because it is situated in Khudra Hazara village. Isn't it?
It's the report.
That's it.
Yes, Lord.
So you need the cabinet approval.
This my.
Is it required? You are not changing anything. And what my question is, on 28/11/2019, the district commissioner have given reasons.
Yes, Lordship.
Why?
Lordship, that has not been clarified, Lordship, why they have not.
Chalo, we direct the commissioner and secretary, education department, and commissioner and secretary, what is your department? Health and family, to come up.
No,
Not by you. These small people cannot do anything.
Lordship, we have
No, Lordship.
received the instruction, Lordship. We do not have.
No, your instruction is okay. You have no authority, you say.
Yes, but we
So
do not have
therefore, let us hear the authority from whoever it is. You, in the meantime, you have a copy, both of you have got the copy of the document which was submitted to the director of this elementary and all. You have the
That is
copy.
annexed in the writ petition.
Fantastic. You also have it. So you forward it to that commissioner and let us be given an update by the commissioner and secretary to the government of Assam's
1 and 2.
education department and by the health department. In pursuance to the order dated 19/6/2026, Mr. D. Upamanyu appearing on behalf of the Elementary Education Department
For the health service department, health and family welfare department submits that the director of health service Assam has no authority.
Lordship, currently there is no director of health services, Lordship. He has retired on 31st, Lordship. So the in charge has.
Then what is it? What is your instruction?
Instruction is to seek time, Lordship, because he has just.
I'm not asking you. I'm only asking the reasons. I'm not asking you to change it. What was my order? By the director to place on record the reasons as to why the said communication issued by the district commissioner Amingaon have not been acted upon.
Yes, Lordship, that is the current.
That also the director edition the year cannot say. This matter has been pending from 2020 and your director has retired only to yesterday or day before yesterday or whatever may be. You cannot provide the instructions. Okay. Submits that the in charge director of health service cannot provide instructions as to why the communication issued by the district commissioner Kamrup Amingaon on 28/11/2019 have not been acted upon. Ms. So-and-so, the learned counsel who appears on behalf of the secondary education department submits that the secondary education department has, why you are giving me some inspector's office? We are not concerned with that. Submits that she has also no instructions on the matter. Consequently, this court therefore, as both the standing councils are in possession of the communication dated 28/11/2019 issued by the District Commissioner Kamrup Amingaon, they shall place this communication before the Commissioner and Secretary to the Government of Assam, Health and Family Welfare Department, as well as the Commissioner and Secretary to the Government of Assam, School Education Department, and obtain instructions obtain instructions and the instructions from as to why the District Commissioner Kamrup Amingaon communication cannot be acted upon. Affidavits be filed by the commissioner by an officer in the Health and Family Welfare Department as well as the Direct Education Department of the Government of Assam, not below the rank of the Commissioner and Secretary to the Government of Assam, as to why the communication dated 28/11/2019 by the District Commissioner Kamrup Amingaon have not been acted upon. When? Day after? Monday?
Lordship.
This matter again on 24th of August 2026. In the meantime, the affidavit be filed by 21st of August. এখন ঘুরাই দিব কোন ইন্সপেক্টর Yes, what is this, Mr. Sharma?
My lord, the matter relates to cancellation of my lord fair price shop license, my lord. Initially, my lord.
Affidavit file?
No, my lord.
We have received the original record, my lord. We have received the original record, my lord.
And what is the ground on which you are selling?
My lord, initially my license has been suspended, my lord. That is by the additional deputy commissioner, my lord. Subsequently, my lord, a proceeding has been initiated, my lord. That was by the my lord additional deputy commissioner, my lord. And the final order of cancellation has been passed by the deputy director. My submission before this honorable court that the licensing authority, as per clause 15 of some orders of 1982, public distributions of orders 1982, my lord, the licensing authority has the power to, my lord, cancel the, my lord, license. So, my lord, the proceeding has been initiated by the ADC by issuing so-cause notice, my lord, to me, to which I have replied. And so my concern is that the My lord, very initiation of the proceeding, my lord, is vitiated.
Why?
But because the ADC has, my lord, initiated the proceeding who has no authority, because he is not the licensing authority.
Who is the licensing?
Deputy Director, my lord, of Food and Civil
Deputy
Supplies.
Director is the licensing authority.
My lord.
So it is the
My
only by
license, my lord, I have also annexed, that is the issued by the Deputy Director.
Where is the so-called notice?
So was notice page 61.
Huh?
Page 61.
Page
61, my lord.
So-called notice. Additional Deputy Commissioner. Then you submit your reply.
My lord, I have submitted my reply, my lord.
You taken that ground.
Yes, my lord.
That show me in the reply you have taken the ground, you have no authority.
Yes. My lord, that ground, my lord, in my reply, I have not taken, but in appeal before the, my lord, divisional commissioner, that I have taken, my lord. Because against the cancellation order, I have filed an appeal before the, my lord, divisional commissioner.
But if it is not the ground taken out there, you don't have the power, you are therefore not challenge the inquiry.
My lord, my cancellation order, lordship will find that, page 8. This was by the Deputy Director, Food and Civil Supplies.
It is, order is being given by the Deputy Director.
My lord. Against that, my lord, I have prepared an appeal, my lord. Commissioner, that has been-
Understood. Now, you say the so-called notice also has to be issued by the Deputy Director.
by the licensing authority.
But you have not challenged that.
In this present,
In that notice, you did not challenge that issue.
while replying, my lord, that I have not,
So if you have not issued,
but my lord, in the appeal before the, my lord, divisional commissioner.
forget about the appeal. Appeal cannot be nothing new. Appeal is on the basis, but can you raise the issue when the order has been, yes, I would have understood. Now, the power which is you are saying about the General Clauses Act. General Clauses Act says the power to appoint includes the power to, what you call? Power to appoint or the power to grant also includes the power not to grant or whatever it may be, or cancel, power to cancel. So the power which is being issued to grant you the license is being cancelled by the person who has the power.
My lord, that has not cancelled, my lord. They have initiated the proceeding.
Power, on what basis, on what proposition of law you say that the proceedings cannot be initiated by the Deputy Commissioner?
Because, my lord, the clause 15, my lord, says that after the proceeding, my lord, they can cancel.
What?
They can, my lord.
I'm not, that I know, but my question is, why are you challenging the jurisdiction for issuance of the show cause?
Because the cancellation is, my lord, the power vested on the Deputy Director.
So therefore, the cancellation has been done by the Deputy Director.
On the basis
So
of which,
therefore, where is your proposition of law starts from? I understand the General Clauses Act, Section 21. Kindly see 21. Power to issue to include, this is a power to issue. The central act or the so and so has the power exercisable in the like manner and subject to the sections of the power to issue notification on the also includes the power to 16. Central government need time. Power to suspend or dismiss. Whereby a central actor power has been at the appointment is conferred, then unless different intention appears, the power as the so-and-so. But from where are you deriving this proposition of law?
The 15, my lord, clause 15, my lord, is
Huh?
clause 15 of the, my lord, public distributions order, my lord, 1982, my lord. Says that, my lord, may, if lordship pardon,
Please.
if any licensee or his agent or servant or any other persons acting on his behalf contravenes any of the terms and conditions of the license, then without prejudice to any other actions that may be taken under the Essential Commodities Act 1955, his license may be cancelled or suspended by an order in writing of the licensing authority. And an entry will be made in his license relating to such suspensions or cancellation. Clause 15(2). No order of cancellation shall be made unless under this clause, unless the licensee has been given reasonable opportunity of stating his case against the proposed cancellation, but during the pendency or in contemplation of the proceeding of cancellations of the license can be suspended for a period not exceeding 90 days without giving any opportunity to the licensee of stating his case.
So, where does it say that the proceedings has to be initiated only by the licensing authority? It doesn't say so. An opportunity of hearing is to be given.
But
Now if we pass any further orders out here, we'll be enlarging the scope of 15(2). There's no quarrel. The power which is being given to vested upon if your license have been issued by A, it has to be only by A. Or even suspended by A also.
That's
Power to grant also includes the power to suspend.
But in my case, suspension order also issued.
That may be wrong, but we are not on the power to suspend. We are on the power to cancel. The power to cancel has been done by the rightful person. So
But
why you are saying now that this person did not have the power to inquire?
No, my lord. My submission is that if cancellations order has passed following, my lord, based on the, my lord, proceeding.
Where is it mentioned that it is only the licensing authority who has to inquire?
My lord, my submission is that, my lord, since the, my lord, the power to cancel has been vested on the, my lord, the licensing authority. So, my lord, the proceeding has to be initiated by the licensing authority, my lord.
Difficult.
Other grounds also there, my lord.
Other grounds?
Other grounds, my lord, the appeal filed before the, my lord, divisional commissioner, my lord, that lordship will find that page.
Where is the order of the divisional commission?
125, my lord.
In where petition filed by the recording. Inquiry and submitted. In beginning of work. Is the appellate order?
By the divisional commissioner, my lord. Some division. Here, lordship will find this order has passed without hearing the petitioner, my lord. Grounds, my lord, urged in the, my lord, memo of will, there is no any finding as regards my grounds urged in the, my lord, memo of will, my lord.
A hopelessly passed order. He doesn't have a good ground, but then other case he had no ground, but this is a hopelessly passed order.
Yes.
We set aside this order, directed the appellate authority to again look into it.
Yes, madam. Giving an
That is the
opportunity of
only
hearing.
way I can do it. But the moment you raise those grounds here, and if I look into it, then matter goes. Your case is bad. That is the only satisfaction you can have. Heard Mr. R. Sharma, the learned counsel, appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent number 1, 2, all the respondents. All the respondents. The present petition has been filed by the petitioner, agreed by the order dated
I have challenged all the orders, my lord, suspension, cancellations and this.
Suspension has gone for a 6. Challenging the appellate order dated 15/9/2021 issued by the Commissioner, Lower Assam Division, Gauhati. Now, do you have that commissioner?
My lord, secretary, my lord, is
Who is the appellate authority?
secretary.
There is a one more.
Huh?
There is one notification, my lord. Now who is the appellate authority, my lord?
Who will be the appellate authority?
My lord, at present, my lord, I don't have the notification, my lord. I'll provide you.
Let's have it on Wednesday. In the meantime, you find out, give it here. Good stuff. This court inquired with Mr. M. Setia, the learned counsel, appearing on behalf of the respondents as to who presently is the appellate authority to consider an appeal against an order passed under clause 15 of the Assam
Public distribution of article orders, 1982.
1982. Taking into account that the office of the commissioner is no longer in existence. Is the matter on Wednesday good?
Yeah, please. Yesterday, respondent filed affidavit in opposition, my lord. And I reply, my
Matter pertains to what?
Some cancellation of their NGO, they were an NGO and running some shelter home, adoption. Adoption center. They did not follow that. Ultimately, that was cancelled. You find the affidavit.
affidavit is not on record.
Where is the impugn order?
24, my lord.
It was cancelled where? Page?
Page 24, my lord, annexure 8.
24.
my lord.
15th May 2017.
Now, what is your ground which you are making?
Lordship,
What is your ground on which you are challenging?
Brown, my lord, they stated that, my lord, I am not no single beneficiary I could not, my lord, found, my lord. And it is the duty of the Child Welfare Committee to produce the children, my lord. It is the duty of the Child Welfare Committee to produce the children in the child adoption.
Produce what?
For adoption, my lord.
They are not providing
No,
the child.
no, no, my lord.
If they are not providing the child, what are you going to do?
And now, my lord, they
Why do you want it then?
now they filed and they are taken stand another stand, my lord.
You, Mr. Talukar, you look into their additional affidavit file. And on the basis of that, you submit your affidavit. They are taking many grounds which were not there in the writ petition, isn't it? There are two ways of it. One is whether I may ask them to, they have submitted two representations which have not been considered by you. That is one way of disposing it. The second is going into the merit as to whether it could have been disposed of in terms with the guidelines which were there operating. For that, we require your stand.
We have already filed, my lord, one affidavit.
Is not on record.
Probably not on record. It was filed yesterday.
Yesterday, my lord. I need to reply, file reply.
When did they file?
Yesterday.
Yesterday they filed, my lord.
You have filed. It has been brought to the notice of this court that the state have filed their affidavit in opposition. Mr. So-and-so, who appears on behalf of the respondent, petitioner submits that an opportunity being granted to the petitioner to file a reply. Again on 18th of September 2026. In the meantime, the reply be filed.
Most of.
The registry in the meantime shall bring on record the affidavit filed by the state. 17. One thing, in view of this, let the petitioner submit their applications and you consider it, taking into account that this is already there.
Department has
There are
received
two
the
grounds
proposal.
of litigation.
The department had received the proposal in 2018, Lordship, but the district commissioner is requested to send a fresh proposal, actually, as per the 2019 policy.
So they don't need to file any application.
District commissioner will send.
So if the deputy commissioner is going to send, we keep the matter pending, directing
Let
you.
them file a fresh proposal because it was of earlier, they have said now new requirement as per 2019 policy, let them file a proposal application. Thank you for this. Let them file a fresh proposal, Lordship. They will consider in terms of that earlier. Oh.
Maybe.
Residing there, na?
Yes, Lordship.
One thing, we protect their possession.
Lordship.
Don't do anything till you don't consider and dispose of. And thereupon, and if you reject it, granting liberty, the petitioner to again approach.
My lord, in 2014, Lordship, there is a proposal, Lordship.
So they lost that.
Yesterday, Lordship, the circle officer, Lordship, called Lordship is this 31 number of petitioners, the 31 number of petitioner before the Lordship, circle office, Lordship, Algapu, Lordship, and asked to submit fresh, Lordship, application along with the affidavit, giving the Lordship
Submit
the
that.
possession certificate, Lordship.
Submit that, you have those possession certificates.
Yes, Lordship.
So submit it.
Lordship, after inquiry, Lordship, this
Submit all the documents which are necessary, which are there with you. Submit all these documents to them. They are directed to reinitiate or submit a fresh proposal because the revenue, they have lost their files. So you submit it and they will consider it by taking into account that order, earlier order passed, as well as this order which I am passing now. And as per the Assam land policy of 2019.
But Lordship, our Lordship, grievances, Lordship, prior to 2019 Lordship, land policy Lordship. This is Lordship 2014, Lordship is since Lordship,
You indigenous people or not? You are. Then what is the problem? Don't think there's any problem with you.
We are in possession, Lordship.
I'm protecting you by my order.
Lordship.
This is the second round of litigation.
This is the third round of litigation.
This is the third round of litigation filed by the petitioners seeking settlement of land. Petitioners herein in the earlier rounds of litigation, the material facts relevant are that the petitioners, along with 56 persons, are members of an association, namely River Erosion Affected Persons Demand Committee Panchgram, Hailakandi. The petitioners, along with the other flood and erosion affected persons, were in possession of plot of land at measuring 1 bigha 10 katha, covered by DAG number 433 under Moja Panchgram, Hailakandi. A representation was submitted on 14/1/1991 before the Deputy Commissioner Hailakandi, praying for settlement of the said land to the petitioners and other members of the said association. The Land Advisory Committee, Hailakandi, in the meeting held on 10/3/1993, decided to consider verify the cases of 4 flood and river erosion affected persons mentioned at serial number ACDI of the resolution number 5 of the said meeting. The other persons mentioned in the resolution number 5 of the said meeting were not flood and erosion affected persons. However, as no lands were allotted to the members of the association of the petitioners, a writ petition was filed before this court, which was registered and numbered as CR number 736 of 1995, seeking direction to the authorities for settlement of the aforesaid plot of land covered by DAG number 433 in the respective possession of the members of the said association. This court, by the judgment and order dated 16/3/1999, directed the respondent authorities to examine the individual cases of the river erosion affected persons and to take necessary action thereupon for settlement of the land in their respective possession within a period of 4 months from the date of receipt of the judgment and order dated 16/3/1999. It is the case of the petitioners that the respondents did not consider the case of the petitioners as well as the other river erosion affected persons. Rather, were taking steps for forceful eviction of the petitioner. Resultantly, the secretary of the association, wherein the petitioners are members, filed a writ petition before this court, which was registered and numbered as WPC number 7994/2005. The said writ petition was The said writ petition was disposed of by an order dated 17/5/2007 with a direction to the respondent authorities to act in accordance with the order judgment dated 16/3/1999 passed in CR number 736 of 1995. Thereupon, the Assistant Settlement Officer, Algapur Circle, Hailakandi, by the letter dated 3/6/2008, informed the Deputy Commissioner Hailakandi that allotment of land to river erosion affected has been re-examined, stating inter alia that the erosion affected families at Panchkram, Hailakandi are local residents and poor persons. And have no alternative land. In spite of the said report submitted by the Assistant Settlement Officer, the Deputy Commissioner, Hailakandi, did not take any action. For which the petitioners filed another writ petition, which was registered and numbered as WPC number 4183/2008. In the said proceedings, the Assistant Settlement Officer submitted a detailed status report dated 6/6/2014 in respect to DAG number 433, showing the respective possession of the 56 persons over the plot of land covered by DAG number 433, who were members of the association wherein the petitioners were who were members of the association wherein the petitioners were also members. It was also mentioned that in DAG number 433, 6 bighas 7 katha 1 chatak of land it was also mentioned that the total land in Dag number 433 is 6 bighas, 7 chatak, kotha, 1 chatak. And out of that, some portion of the land have been allotted to some other persons and periodic pattas have been issued. And there still remain 5 bighas, 5 kotha, 1 chatak. It was also, in addition to that, it was mentioned in the report that an area of 1 bigha or 10 katha are in physical possession of the members of the association, being petitioners in WPC number 4183/2008. This court, taking into account the state report dated 6/6/2014 and other reports by the order dated 23/7/2014, where is that order?
My lord, page 61, Lordship. Annexure 9, Lordship. Pertaining portion, Lordship, page 63.
Dispose of the petition by an order dated 23/7/2014. Thereby directing the official respondents to complete the process of rehabilitation and grant of patta to flood affected families after verification of the report within 3 months. It is the further case of the petitioners that pursuant thereto, the Subdivisional Land Advisory Committee in its meeting held on 28/5/2018 reduce the number of flood and river erosion affected families at Panchgram in Hailakandi district also reduce the area of land in respective possession of the flood and erosion affected families over the land covered by DAG number 433. That too without hearing the petitioners. It is under such circumstances the petitioners approach this court, challenging the minutes of the meeting dated 28/5/2018 of the Subdivisional Land Advisory Committee, and further seeking a direction that the petitioners should be granted settlement in terms with the status report dated 6/6/2014 submitted by the Assistant Settlement Officer, which was placed before this court. The record reveals that this court, by an order dated 3/8/2022, issued notice an affidavit in opposition was filed by the respondent number 4 on 22/3/2024. Wherein it was mentioned that out of the 56 members of the river erosion affected persons demand committee Panchgram Hailakandi, only 31 members were found to be in possession of the government land under second RS DAG number 433 bracket PT of Moza Panchgram under Algapur Revenue Circle. And accordingly, the concerned assistant settlement officer submitted proposal for allotment of land under the said DAG bracket as per their possession. The said proposal was placed before the Subdivisional Land Advisory Committee, Hailakandi, in the meeting dated 28/5/2018. And the SDLAC recommended the said proposal by resolution number 1. The said proposal thereupon was forwarded to the government by a communication dated 19/7/2018. It was further mentioned that as regards the rest of the members of the association could not be ascertained by the concerned assistant settlement officer during the re-verification of the re-enquiry by the concerned assistant settlement officer. And as such, no application for allotment of land could be obtained from them who perhaps resided elsewhere in their alternative lands. It is very pertinent to take note of Annexure A to the said affidavit. Your name is there?
Yes, Lordship.
Wherein the steps wherein the communication dated 19/7/2018 have been enclosed. A perusal of Annexure A to the said document clearly reveals the names of 31 persons which were forwarded to the government for settlement. The total land for settlement was 14 kathas 02 chataks. The petitioner's name features at serial number 1 and 2, isn't it?
Lordship. 1 and Lordship.
1L?
1 and 26.
1 and 26. Ranjit Sinha. And number 1. That the petitioner's name features.
This court, when the writ petition was listed before this court on 22/6/2026, this court observed that the affidavit so filed by the respondent number 4 was inadequate. Under such circumstances, the District Commissioner Hailakandi and the Revenue and Disaster Management Department were directed to apprise this court as to what steps have been taken towards granting the settlement allotment of the land to the petitioners as well as the 29 others whose names were forwarded. In pursuance thereto, a communication issued by the Additional Secretary to the Government of Assam, Revenue and Disaster Management (SNS) Department, dated 6/8/2026, was placed before this court by Ms. So-and-so, appearing the Standing Counsel of the Revenue and Disaster Management Department. From a perusal of the said communication is kept on record and marked with the letter X. From a perusal of the said communication, it is seen that the Revenue Department could not trace out the physical file of the documents which were forwarded by the Office of the District Commissioner. However, in order to avoid any delay due to non-availability of the physical records, the department had asked the District Commissioner Hailakandi to submit a fresh individual proposals for settlement of government land at measuring 14 katha 02 chataks covered by second RS Dag number 433 part of Moja Panchgram in favor of the petitioners and 30 others in favor of the 30 petitioners and 29 others erosion affected family, together with all requisite documents as prescribed under the extent, rules and the Assam land policy of 2019. Taking into account that there would be a requirement for submission of fresh proposals, it is the opinion of this court that appropriate directions can be passed in the present proceedings. And this court is the opinion of this court that the instant writ petition can be disposed of by passing appropriate directions. Accordingly, the writ petition stands disposed of with the following observations and directions. The materials on record clearly indicate that the petitioners herein, along with 29 others, have been were found to be eligible for allotment of government land, which is a part of Dag number 433. This aspect is apparent from the communication which was issued by the Deputy Commissioner Hailakandi, dated 19/7/2018, read with the annexure A to the said document, number 1. The petitioners herein, along with, the petitioners herein shall file their specific shall submit applications for allotment, public settlement of the land under their possession. Taking into account the remaining 29 other erosion affected persons are not parties to the present proceedings. The District Commissioner Hailakandi as well as the Circle Officer of the Algapur Revenue Circle are jointly and severely directed to inform the other 29 persons to submit their applications for allotment. In addition to that, this court grants liberty to the remaining 29 persons to also submit the applications even without the intervention of the district commissioner, Hailakandi, or the circle officer so and so. Number 3. Upon such applications being submitted, the district commissioner, Hailakandi, shall prepare a revised proposal based upon the various orders being passed by this court, reference to which this court have already made in the body of the present judgment. The revised proposal be submitted within 3 months from the receipt of the respective applications. This court further directs the Revenue and Disaster Management Department to thereupon consider the revised proposals in accordance with law in the light of the observations made in the light of the various directions passed by this court in the various orders referred to herein above, as well as the present judgment. And also the Assam land policy of 2019. Taking into account that the claim of the petitioners, that the petitioners have been running from pillar to post, the petitioners along with the other erosion affected families are running from pillar to post for the last 36 years, 35 years. This court observes that the Revenue Department shall complete the exercise within a period of 6 months from the receipt of the revised proposal. Next. This court makes it very clear that this court finds it, this court observes and directs that during the pendency of the proposals before the district commissioner and or the revenue department, the respondent authorities under no circumstances shall take any steps for eviction of the petitioners. It is further observed that in the circumstance the proposals are rejected, steps for eviction can only be taken by following the mandate of Muhammad Salahuddin. I gave you everything.
So the issue is with regard to a construction of a PWD road over the petitioner's Patta land. So Lordship will kindly have a look at page number 12. But the petitioner is the owner of a plot of land measuring 1 bigha 2 katha 10 lesa.
Notice.
carried out the demarcation.
Lordship, this is not whether notice was served, notice was issued or not. This was on the last occasion. Court has asked whether notice has been issued prior to eviction. This is the notice, Lordship.
So in DAG number 20,
20.
petitioners are owners of which DAG? 21.
21.
And
20 is the PWD road.
PWD road.
and you are not in DAG number 20.
No, encroacher of DAG number 20. They are encroacher.
If your lordship will kindly have a look at the map, 22A. 22.
No, I'm not going to look into this. You have carried out the demarcation on the 20.
Yes.
If it is 20, then if there is anybody to remove them by whatever may be, the petitioners cannot also claim on road. There is no right out there. You have issued notice?
Lordship, yes.
Put him out from 20. And if he has any problem, go to the civil court, not here. Is 20 or 21, we cannot look into. Yes, from 21 you cannot be. They say that they have carried out the demarcation and found out that it is. And if you have anything, then it is a civil court. We cannot ask them to look more and more. There's no quarrel that you are the owner of 20, they duly recognize.
Owner of 21.
21.
They are occupying 20.
20 you cannot. You have no right. And you are also not claiming any bona fide claim of right on for 20. So therefore nothing. So you can go ahead in 20. Eviction done.
Done, Lordship.
Huh?
Already done.
Nothing. Just withdraw. No case. The only way out is for you to go to the civil court.
That liberty may be given.
Pursuant to the order dated 15/7/2026, Mr. S.S. Roy, the learned counsel, appearing on behalf of the district administration of
4 and 5.
which one?
Borpeta district.
Borpeta,
Lordship.
has submitted that due eviction notices were issued on 19/1/2023. And further, the road was constructed only in DAG number 20 and not in the DAG number 19 and 21. Stop. A patta number?
Patta number is my lord, 184.
Of 184. Stop. It is the opinion of this court that in view of the demarcation being carried out and the specific stand by the respondents that the road is constructed in DAG number 20 and not in the petitioner's land. Eviction was carried out by following the due process only in respect to DAG number 20. This court cannot enter into the factual adjudication as to whether while carrying out the eviction in DAG number 20, the respondents have encroached or trespassed into the DAG number 21 of the petitioner. Considering the above, this court therefore is not inclined to entertain the instant writ petition, for which the writ petition stands dismissed. The dismissal of the instant writ petition, however, shall not preclude or prejudice the petitioner to avail remedies before the competent court of civil jurisdiction.
If your lordship would like
The
to
instruction which have been placed by Mr. S.S. Roy is kept on record and marked with the letter X.
the photos which we had annexed in the additional affidavit matter, it clearly shows that the eviction was done on the eastern side of the land.
Understood. The problem lies there, those photos, whether you have encroached upon his land
or he has encroached upon your land, how can we say?
But the 20 lies in the western side of the land, and the eviction was done on the eastern side. Highly obliged.
Civil court will help you out. এই এহেঁতলোকৰ নামবোৰ আগত লিখি দিব দেই, hard so and so so. What is this?
My lord, this pertains to, my lord, classification of land. In the year 2018, my lord, approval was granted.
Affidavit file.
Affidavits have been filed, my lord. The issue that had arisen, my lord, is that though in 2018 the approval was granted for conversion from agricultural to commercial, in 2021 I deposited the premium also. Thereafter, the NOC as required under section 5.7 by the deputy commissioner was not issued. Then we found out that they had made a query further with the forest department that whether it falls within the eco-sensitive zone of Amsan. It definitely falls, my lord, within the eco-sensitive zone. But then, however, the forest department says that it is otherwise surrounded by commercial properties. So from forest side, there was no objection. Then when we filed the writ petition, my lord, the issue again comes, my lord, that since it is eco-sensitive zone, we cannot permit conversion into commercial, my lord. Then I produced the notification, my lord, pertaining to Amsang eco-sensitive zone, that there are certain activities that are being regulated or prohibited. My lord, the polluting activities are prohibited. Everything else is regulated. So there is no per se bar in that notification saying that there cannot be a commercial land within a eco-sensitive zone. Only restriction is that certain activities cannot be carried out, my lord. So therefore, my humble submission is that the conversion as such cannot be stopped, my lord. Though I can in future be restricted by that particular notification as far as eco-sensitive zone is concerned to carry out certain activities which are only permitted or be prohibited from carrying out activities which are not permitted, my lord, as per the notification.
Urgency, no urgency.
My lord, I've been waiting for a long time, my lord, in this matter. 2021, I had already deposited the premium. 6 years, my lord, no decision taken till on this matter.
You did it when?
In 2021, my lord, I was asked to deposit the premium. 3,27,000 I deposited.
Pleadings complete?
Pleadings completed, my lord.
Pleadings be complete, list this matter for final disposal on 22nd of September 2026.
I have produced one instruction, my lord.
What is this instruction?
Whether agricultural land lordship in terms of order dated 25/26.
Yes, Lord.
Agriculture conversion. Lordship. 25/2026.
25, 20?
Huh?
Yeah, which order you are referring to?
In my
29, my lord. 29.5.
Yet to receive the instruction has been sought. What is the instruction sought for?
that the whether specifically whether agricultural land can be reclassified for commercial activities without maintaining the business to be carried out.
Where is that? Who has raised it?
Lordship. By this.
We have to go as per that act.
My lord.
If the act does not say, they have no business. Time sensitive, eco-sensitive has no business.
My lord. Act says that, my lord, basically reclassification is done if the surrounding land, there is no agricultural activity carried out for 10 years.
An affidavit in the meantime. The SS Roy, the learned counsel has placed certain instruction which in the opinion of this court be brought on record by filing an affidavit. The affidavit be filed on or before 17th of August 2026. Only that, nothing.
Gotcha.
This matter again. What is this?
Lordship, if your lordship remembers, under section 16.4, there were several demands.
Oh, yes, that day I was about to dispose it of. Now, the problem I did not, I was thinking, but here
your main point comes under 31-3. Your order is on 13-3-2020. Your case will come under 09.
His Lordship, notification I am not pressing as of now because 16.4, it used to say that if your return is filed within so and so date, you will get input tax credit. Since the assessee had filed a bit late, that's why the demand was there. But subsequently in Finance Act 2024, section 16.5 was inserted. As per
By
that, it is within time.
Can take care of
We disposed of Lordship.
in view of the amendment. That should have been told. So there was a direction to file the application within a period, or by operation of law it will be taken.
By the order itself, Lordship, the date has been recorded in the impugned order itself and it is within time. I am showing it to your Lordship.
Section
Where, where,
16.5.
39, Lordship, the order.
This is regarding there were two sets of the challenge.
Lordship.
One was where it is covered by the Finance Act 2024.
Lordship.
The other was 56.
Notification 56. That orders passed in the month of April.
So 56 is the one which I took it up.
Your Lordship said
And I think the
9 is pending.
criteria, huh?
9 is pending. Notification 9 is still pending.
But anyway, but Justice Saikia took note of the other one, I suppose. Any order passed to the
No.
That order is not there, but those which were closed by covered.
Lordship is not,
Any other court also has not.
No, not 9. And 9 has been decided, upheld by Kerala.
Yes.
Held by Kerala. On 56 is on a different.
Yes.
There's nothing to do with 9.
Lordship, yes.
9 is an interesting point on the question of as to whether you can do so on the basis of whether there was an act
Force measure.
beyond the control, which is there. 168A could have been exercised if it is.
Lordship.
But while holding in 56, I held that the government cannot on the own say so.
was no
The GST recommends the existence of the conditions under 160.
Yes, Lordship.
So once that recommendation, therefore I set aside. Now here is being taken care of by this.
Section 16.5, Lordship will first take care of the impugned order, page 41, Lordship. Page 39 it starts. 41 is the relevant table, Lordship. The demand is of 3 components, total 84 lakhs. Date of return filing is mentioned in the order.
Page 41, 84 lakhs, yes.
Date of return filing is relevant, Lordship, in the table.
Yes.
23/10/2019, Lordship.
This is for the year 18-19.
Yes, Lordship, 18. Now, Lordship will produce section 16.5 and 16.4.
16.5 takes note.
Yes, Lordship. First 16.4, Lordship. If I may please read.
So you file the return on 19. And here it is given till November 2020.
Lordship.
So now what order can we pass now?
The order in the
This is only the issue.
Yes, only this.
No other one.
No other
We've
issue,
looked into it properly. Last time because of
Sir,
you,
actually, last time there was a confusion in the synopsis, Lordship, they are written like that. This point was not,
So therefore, the show cause notice proposes the recovery of the wrongly availed unutilized ITC so and so. so and so under section 73 along with applicable interest on it. So this is only for wrongly availed ITC.
Yes, Lordship.
So this is being duly taken note of because admissible AI because the return date of filing of the return is 2310.
So it is now admissible.
So normally for 1819 it should have been filed when?
1819 Lordship, the order mentions
For 16.4.
30th
They have been
November.
filed. Registered person shall not be entitled to take input tax credit in respect of any invoice or debit note for supply of service or both. It. Note pertain furnishing of the relief, so whichever is earlier. Let us see the order. Has availed and utilized
Page 40, Lordship.
effect of invoice after the prescribed time. Thus ITC amounting to so and so. Okay. Heard Mr. D. Saraf, the learned counsel appearing on behalf of the Mr. Mikael, the learned senior counsel assisted by so and so appears on behalf of the respondent number
3, 4, 5, and 6.
two.
3, 2 lots of state is there.
Is not the 1, 3, 4, 5, and 6.
Not
And appears on behalf of the Finance and Taxation Department of the Government of Assam.
Lordship had asked the date, it is 2010-2019.
Which one?
Filing as per the earlier law.
The present petition has been filed by the petitioner, being aggrieved by the order dated. Order in original dated 13/3/2024. Primarily on the ground that primarily on two grounds. The first ground is as regards the extension of the period for exercise of powers under section 73 of the Act, Central Goods and Service Tax Act 2017 by notification number 9/23 CE dated so and so. What is the date?
31/3/2023.
23.
31/3/2023.
31/3/2023. The second ground is that the petitioner having already submitted the return on 23/10/2019, the petitioner should have been granted the benefit of the ITC availed utilized. Mr. D. Saraf, the learned counsel appearing on behalf of the petitioner submits that taking into amendment of the section 16 of the Act of 2017 by the Finance Act of 2024.
Has been inserted. Was not there.
Which came into effect whereby section 16(5) was inserted, the instant petition can be disposed of on the basis of the said, on the basis of section 16(5) of the Act of 2017. Taking into account the said submission, this court finds it relevant to take note of, reproduce subsection 5 of section 16 of the Act of 2017.
A perusal of the above quoted subsection would show that notwithstanding anything contained in subsection 4, in respect of any invoice or debit note for supply of goods or service or both pertaining to the financial years 2017, 18, 18, 19 and 19, 20 and 2021, the registered person shall be entitled to take input tax credit in any return under section 39, which is filed up to the 30th day of November 2021. In the instant case, from a perusal of the order in original dated 13/3/2024, it is apparent that the petitioner had submitted the return on 23/10/2019 for the financial year 2018-19. Under such circumstances, it is therefore the opinion of this court that the benefit of the ITC claimed amounting to 84,58,480, isn't that? Yes. No, the amount is 84. Cannot be denied in view of section 16(5) of the Act of so and so. In that view of the matter, the impugned order in original dated so and so is required to be interfered with. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. The impugned order dated so and so, passed by so and so, then set aside and quashed.
So cause also goes.
And stays aside and quashed, then there is no order, no? Because so cause is something else. Tomorrow you may also say that a notice issued under section 70 also should go.
No, Lordship.
My question is, where is the question of so cause? Once the order has already been finally passed,
Obliged.
aside and quashed. No.
Your Lordship. Trying to file an affidavit in reply, Your Lordship, some further time, Your Lordship. They have come,
Counsel appearing on behalf of the petitioner. What is the matter about?
the refusal of granting arms license, Your Lordship. They have filed an affidavit in opposition that there is a case pending against me. I have just obtained the final report of that FIR, Your Lordship. I want to bring it on record by way of an affidavit on reply, Your Lordship.
I gave you time from 10/6/2026.
So the FIR was, didn't came to me, Your Lordship.
Well, appearing on behalf of the petitioner submits some more time is required for filing the affidavit in reply. It is noticed that this court had granted time to the petitioner on 10/6/2026 as well as on 22/7/2026 to bring on record the affidavit in reply. However, the petitioner have again sought for time. Taking into account the above, it does not seem there is urgency in the instant proceedings. Accordingly, list this matter on 28th of November 2026. In the meantime, the petitioner would be at liberty to bring on record their stand by filing the.
If I'm, Your Lordship, in the earlier case, maybe I have filed an affidavit in reply.
I'm not here. I'm concerned here. There are 2 dates. You have not filed. So therefore, 20 November.
May I please, Your Lordship? I have received prior comment, Lordship, only yesterday, Lordship.
You?
I'm for the BTC, Lordship.
Ah. Is your comments?
Lordship.
Your case.
What had happened, Lordship? A land measuring 0 vika, 3 kata, 5 losa was given approval by the subdivision land advisory committee, Lordship. And thereafter, the respondent number 3 directed the respondent number 5 for allotment of the said land, Lordship, and correction of record. But subsequently, what had happened, Lordship? a letter was issued by the respondent number 5 regarding that the allotted land is only about 2 vigha lordship, 2 kotha, 11 losses lordship, deducting 14 lessons from the earlier approval lordship.
What you are asking that giving approval to only 2 katha 11 lectures to the petitioner instead of 3 katha 5 lectures.
Lordship.
Not to cancel the allotment of the land admeasuring so and so covered by approval of the Iman, held on Iman. So they have given 2 katha 11 lectures.
Previously, they have allotted lordship.
What allotted? Who has allotted you?
They have given approval for 3 kata.
Who has given approval?
Lordship, SDLSC, Lordship.
SDLSC is the authority.
No, Lordship.
Then,
Lordship, kindly peruse page 27.
what
Lordship.
right you have?
Page 27, Lordship.
The way the official record found that the area of so and so covered by so and so highway authority have acquired a carrying 14 lectures out of so and so. Just by the applicant for settlement. Before settlement, office record full of Iman, Jirat value. If has got compensation of you got money.
Lordship, that instruction I have. That instruction I have to take.
Huh?
That instruction I have to take.
You have to take. You have received money also.
Lordship, that instruction I have to take.
You have got 2 katha 11 lectures. You are satisfied?
That instruction, whether I have received the money or not, Lordship, that instruction I have to take, Lordship.
Because on the so and so in his allotted land to BTC in the name of so and so circle. By the 3 katha 11 lectures of so and so was seen as allotted land of so and so. 3 katha so and periodic patta. Yeah. Why there are 2 documents, Mr. Counsel?
Lordship.
The same date. One
Lordship,
is
same date, Lordship.
why?
Same date, 2 documents, Lordship.
Why one saying 3 katha 5 lecture, other saying
Same date, Lordship, 17th of that.
oh, you can't be given that land. You can't be given because you were supposed to get 3 katha 5 lecture.
Lordship.
Out of that 14 lecture has all been acquired. So you can be only given 2 katha 11 lectures. No way out. Land has been acquired.
The due process.
What? The land has been acquired by National Highway. National Highway has done it because through the government land it has been acquired. It has been notified on the 3D. Therefore, the problem arises. Therefore, you can't get that land. And here it further says, as a result, plaintiff means you have got compensation of rupees 22 lakhs 9,089.
On Monday, Lordship.
Okay, we record it in the order because I can't allow him to file any affidavit because we have already mentioned it clearly earlier. Heard Mr. P. Bodlow, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the BTC. Claim of the petitioner herein is that though the revenue authorities of the BTC have approved for settlement of three katha 15 lectures of 5 lectures of land in favor of the petitioner, but the petitioner was only granted settlement of 2 katha 11 lectures. Under such circumstances, the present petition was filed. Pursuant to the order dated 15/6/2026, Mr. So-and-so, the learned standing counsel of the BTC, has placed an instruction issued by the Secretary BTC dated 6/8/2026, which is kept on record and marked with the letter X. From a perusal of the said instruction, it is seen that though initially the petitioner was to be granted the settlement of 3 katha 5 lectures of land, however, 14 lectures of land have been acquired by the National Highway Authority, have been acquired by the Highway Authority. And therefore, the petitioner have been only granted the settlement of 2 katha 11 lectures of land. It is also mentioned that Jirat compensation that only Jirat value compensation can be paid to the also mentioned that the petitioner have got the compensation amount of rupees 22,09089. Mr. P. Bodloy, the learned counsel appearing on behalf of the petitioner, submits that he would obtain instruction in that regard. This matter on 9th of September 2026.
Your Lordship, I'm very sorry to interrupt, Your Lordship. I have gone through the record, Your Lordship. It was not me who took the time on 10/6/2026. It was the respondent side who took time. I only took time on 22/7/26, Your Lordship. Filing the reply, Your Lordship. Number 21.
Because of that, we extended by 2nd November. What is 20th? It is 2nd November.
That has been recorded, Your Lordship.
Next.
May I please, Your Lordship? My Lord, here the case subject matter of the case is that, my Lord, the petitioner bank account has been freezed, my Lord. Petitioner bank account has been freezed, my Lord, and therefore we have filed this writ petition, my Lord. On the last occasion, my Lord, the respondent has submitted that a charge sheet has been submitted in connection with this PS case, my Lord. Now, my submission before this honorable court, my Lord, I am not the accused in the FIR. There are all total eight accused persons. They have taken some loan by giving forced document, my Lord, forced identity.
Understood. My question is on the last occasion, if I remember, when the matter is pending before that authority, why you are not taking an action before in that court? That it is not done under 102, and it is under such circumstances I sought for an instruction as to whether the petitioner would like to pursue the remedy here or file an appropriate proceeding before that court. Taking into account the above, the learned counsel for the petitioner submitted that he would obtain instruction as to whether the petitioner would like to pursue with the present proceeding or file appropriate application before the respective court. But that court is there. So therefore, if there is an attachment, you need to file an application there, because normally where we exercise our jurisdiction is where nothing is there, where there is some, because of some amount being disputed, amount being deposited. Nowadays, I have stopped there also because of their SOP. Go there.
Here, my submission is that, my Lord, in this case, the pleadings has been completed, my Lord. Pleadings has been completed. One question has been arises during the hearing, my Lord, that order has been passed by this honorable court, my Lord, on 19/3/2025.
No, forget about all these other cases. My question
lord-
is on 17/7/2026. I gave you an opportunity to obtain instruction as to whether this court should take it or you would like to pursue it. If you say that no, you'll pursue here, wait at your risk, I may dismiss it also. Because if this court is in a position, because there are already a proceedings out there, you can very well, in that applications ask them, because once they attach, you can very well file application, isn't it?
That by this order, I want to only apprise before this honorable court, my lord, that an amount has been transferred in my account. And this honorable court might order that it as a need and clarify from the bank, my lord. And bank has filed an additional affidavit stating that, yes, only 72,000 has been transferred in my account. And for that amount transferred, my lord, my whole bank account has been.
Is it so?
My lord, kindly produce the order dated 19/3/2025, my lord. 2025.
Is it?
Order dated, my lord.
Is for the reason that some person's name in the accused has fraudulently obtained loan and deposited such amount in the account of the petitioner. Very well.
My lord.
But now you have been charge sheeted. That was then. But today you have been charge sheeted. But therefore, don't you think that you need to file an application there? That is what I'm saying. Earlier, otherwise, this with that order, normally we pass an order that keep a lien on this amount and allow. That we allow. But the question is now, when you are a charge sheeted out there, don't you think that a proper application needs to be filed there? Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submitted that in pursuance to the order dated 17/7/2026, he has obtained instruction not to pursue with the present proceeding and file appropriate applications before the court of the subdivisional magistrate, Rongia, for removing the attachment from the petitioner's bank account. He submitted that the withdrawal of the instant application not prejudice the petitioner or preclude the petitioner in filing such application. Taking into account the above, the petition therefore stands closed. The closure of the instant writ petition shall not prejudice the petitioner. Applications so far in any future proceedings filed before the appropriate court for release of the attachment from his bank account. I have not appropriate forum, huh? Because you may also take the initiative of the SOP. Because SOP also may help you.
Respondents were directed to place the review board.
What happened? Review?
Recommended for release, man.
Recommended for release. Will do. Name of the petitioner?
It's now, my lord, seven, serial 7. Isna Hazarika.
Krishna Hazarika.
Man.
Recommended for you.
Upon.
Hmm?
That may be acted upon.
Excellent. Recommended for release. So your is, you have come before this court on the basis of the rejection
rejection.
Now, in the review meeting, they have accepted and reviewed, or now have recommended for your release. Consider the favorable opinions furnished by so and so, as well as the convicting court. The board also considered the crime committed, the period of sentence area, and also convict statutory. Now, what else do you want from this court?
Acted upon, Lordship.
Something more than what I can do. Your limited case was there. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. The BJ Talukdar, the learned senior counsel assisted by Mr. K. Medi, appears on behalf of the respondent numbers.
All the respondents.
On behalf of all the respondents. The petitioner herein has approached this court by filing the present writ petition, telling the order dated 24/10/2020, telling the memo dated 24/10/2024, and the minutes of the state level review board held on 22/7/2024 in respect to the petitioner. The grievance of the petitioner herein is that both the impugn memo as well as the state level review board on 22/7/2024 did not consider the case of the petitioner in the proper perspective. So, be that as it may, in the meantime, in a review meeting held on 28/7/2026 by the state level review board, the petitioner case have been recommended for release. The said minutes of the state level review board dated 28/7/2026 is kept on record and marked with the letter X. A copy of the same be also furnished to Mr. So-and-so, the learned counsel for the petitioner. Taking into account, nothing further remains in the instant proceedings, and accordingly, this court disposes of the instant proceedings with an observation upon observing inter alia that the state respondents now shall act upon the recommendations so made by the state level review board.
May it please your lordship. Petitioner's son was an accused in a case, your lordship. Subsequently, the residence of the petitioner was demolished, your lordship. There was no notice served upon me, your lordship. If your lordship may kindly peruse the affidavit, counter affidavit filed by the respondents, your lordship. At paragraph number 4 is 36.
Now you have been evicted.
Yes, your lordship.
And your case squarely comes within the ambit of that judgment of Justice Gauhati.
Yes, your lordship.
Merely because of the case, there being a criminal case, you cannot.
Yes, your lordship.
Yes, the learned coordinate bench asked him as to whether the due process was followed.
Yes, your lordship.
And what do they say?
Is
Oh,
they said miking was done, your lordship. Page 36. Paragraph 4. Paragraph 4, your lordship.
now what are you asking?
Rehabilitation.
Evicted, and after that, what happened? I will welt.
Yes.
You are not tribal.
No, your lordship.
And how can you remain there? Any right?
No, your
No
lordship.
right.
The only, I'm only agree with the fact that your lordship, that at least I should have been given a notice, your lordship. No notice
Understood.
was served.
Very well, you should be. But my question is, if the notice has not been issued, the violation of the provisions of law or the directions which have been passed by the Supreme Court. So if the directions are here, now can this court bring the back, put the clock back? And ask them to put him in possession and thereupon
Notice.
to notice and throw you out.
No, your lordship, I understand, your lordship. The only prayer, my mission, your lordship, is that some amount of compensation may be given to me, your lordship. My only respectful prayer.
How many years you have been residing there?
From 93.
From in the year 93, your lordship.
Petition,
93.
from 93, one is from 2020. Page 34, Lordship, we have mentioned.
Compensation will consider later. This is the house.
Yes, your lordship.
It has been broken down.
Yes, your lordship. Demolished.
Only solely you or anybody else?
Who others are there? Who others are also there?
Does also.
As per my instructions, only my residence was destroyed.
As per them?
Yes, sir. According to them, they have a report, your lordship. Two other persons.
How many people were there?
Two others.
Two others. Have you filed your reply? They say two others. Have you filed your reply?
Yes.
What do you say? Was it only you? Because otherwise you're very basis that it is because of your son being involved in a criminal case that has no relevance. If other two are there, what is your reply on that? Hello, look into it.
Your lordship.
When? In a better, cool atmosphere? Chala. Taking into account the pleadings are complete, list this matter on 4th of November 2026.
My lord, here, the case
Yes, why? Pata not issued?
File the affidavit, Lordship.
was made, my lord,
Why?
My lord, Lordship, kindly see page 15 of my affidavit, Lordship. Petitioner only is the allotee, however, no record of counterfoil of the allotment certificate is available in the office of circle officer.
What do you say?
That 4.
Where it says that as per the note so and so in the hand of the petitioner is an allotee. However, no record of counterfoil of the allotment certificate is available to here. What allotment is it?
my lord, in
Where
this,
is the allotment? Show me.
my lord, page number 11 of my read petition, my lord. And in fact, in their affidavit also, my lord, the para 5 in their affidavit, my lord, they have admitted.
Below scheduled land. Terms and conditions. Where is the terms and conditions?
My lord, this portion, my lord,
Not annexed.
in the vernacular also, my lord, only this.
Vernacular it is there, but if we want to refer it, can we only look into one part of the document?
Only one part, my lord. And
why?
Secondly, my lord, the district commission in his affidavit, para 5, my lord, but we will may come to page 15, my lord. In their affidavit, my lord. Para 5, my lord.
Has been allotted in the name of General Abedin and other as per
Journal of the is the present petitioner.
in hand Chitha. However, the applicant has not applied portion from the allotment certificate to periodic patta with requesting documents as per the norms. Hence, no periodic patta could be issued.
Okay. So you apply. So they duly admit that you have been allotted. So therefore, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner.
Yes.
The present writ petition has been filed by the petitioner being aggrieved by the inaction on the part of the respondent authorities in not granting the periodic patta to the petitioner. Though the petitioner was issued an allotment certificate of sealing land under the Assam Fixation of Sealing of Land Holding Act 1956. The allotment certificate, which was issued to the petitioner, has been enclosed as annexure 2 to the writ petition. The record reveals that an affidavit has been filed by the respondent, number 2, wherein it is mentioned that that as per the note dated 27/8/2013 in the Hanchita, the petitioner is shown as an allottee. However, there was no record available of the counterfoil of the allotment certificate in the office of the Circle Officer Nilam Bazar, Revenue Circle. It is also mentioned at paragraph number 5 that as per the record, the schedule of Porgana Dewande, Moza Nilam Bazar, Parampasa Part 1, covered by DAG number 63, had been allotted in the name of the petitioner and others as per note dated 27/8/2013 in Hanchita. However, as the petitioner had not applied for conversion from allotment certificate to periodic patta with requisite document as per norms, the periodic patta has not been issued. The learned counsel appearing on behalf of the petitioner submits that the petitioner would do the needful as is required. So taking into account the above, the instant writ petition therefore stands disposed of with the following observations and directions. Number 1, taking into account that the respondents duly admit that the petitioner is an allottee, the petitioner would have a right to submit an application for claiming the periodic patta. The petitioner is granted the liberty to submit an application claiming the issuance of the periodic patta along with all necessary documents. Upon submission of the said application, the respondent authorities, more particularly the respondent number 2, shall do the needful and complete the exercise within a reasonable period, not exceeding 8 months from today, from the date of submission of the application.
6 months, man.
Huh?
Month.
6 months is for money, 8 months for land.
But here in this case.
Otherwise, Mr. Counsel, you want the 6 months, I know why. Because along with that, you want another brief for contempt.
Here in the next 26, item 26, man.
Unappeared for the petitioner.
26, I'm appealing.
Oh, you appeal.
The parcel land of the petitioner during settlement operation was wrongly made as a government land, and a new DAG was created. An inquiry was conducted through the circle officer. The circle officer in his inquiry report admitted that the declaration of the conversion of the parcel land of the petitioner was wrongly done as government land, my lord. That your lordship will find page number
So there is some status quo.
page
The
number,
affidavit been filed by you.
Lordship.
page number 46, my lord.
Yet
Lordship may
to
kindly
file
come to page
reply,
46.
Lordship, because we have denied he is not in possession, Lordship. We have denied, Lordship, he is in possession.
Have you filed your reply?
This is my part, my lord.
File your reply. When there is a denial, if you don't file your reply, we have to admit.
My lord, I'll file. Otherwise, they are document, my lord. It is their
Just
document.
understood. His document, that document, when there is an affidavit, there is also a necessity for you to submit a reply. Instead of thinking about the contempt, file a reply. Counsel appearing on behalf of the petitioner submits that taking into account that the affidavit has been filed with respondent number 3 only on 27/5/2026, some time may be granted to the petitioner to file an affidavit in reply. Whos- Accordingly, list this matter on 18th of September 2026. In the meantime, the reply be filed. Oh, this one. That day I was, after this matter, I was just thinking why I should not dismiss her petition on the question of locus standi. Where is she? Not there.
She's here.
Yeah, why I should not dismiss her petition on locus standi, taking into account that your office is not a public office.
Exactly, my lord, it's a
And
private.
she cannot ask for a writ of quo warrant. Matter over.
Lordship,
Maintainability of the writ petition. He is not a public office. Who are you?
Lordship, the district commissioner was,
No, forget about district commission. My question is, why should I entertain the? Then the job where he is not a public office. No quo warrant. If I can't issue in all the other matters, you have to satisfy the the locus. Only in quo warranto you don't, but it has to be a public office. And here you don't have a locus. What locus? You intentionally you have asked your child to be studying out there in the school. So, pick your child if you have any problem with that. You cannot challenge all these things. And what is your challenge? That he was not a proper OBC. OBC, na? Oh no, not
NCL.
OBC is there, but he is not a creamy layer. And as such, his admission to that particular college was wrong. And that college, after getting it out, is now the headmaster or principal of some private school. Where your student, your son or daughter is studying, is it? No. We should
Lordship.
dismiss it with cost.
if I may,
No, this
a judgment, Lordship,
judgment is what judge?
regarding maintainability, Lordship.
Huh?
Maintainability, Lordship.
Yes, tell me what is the case?
Lordship.
Have the respondents filed the affidavit?
Well,
What is their step?
Lordship, respondent 3 and 5 have still not filed their affidavit, Lordship.
What happened in this case?
If Lordship may kindly peruse paragraph 13, Lordship.
Where?
Paragraph 13, Lordship.
No, wherever this judgment. This judgment is no, you have another judgment in the case of, what do you call? What that name? Abdul, it has a different name. Abdul. No locus standi. This judgment is different. And this is a Bombay High Court judgment. We are not bound by it.
Lordship.
There is a specific judgment at this point. No locus standi to challenge you are not an OBC. Now here, whether the petitioner is OBC,
Yes, Lordship.
you are an OBC.
Lordship.
Where you are competitor to get that to study that post.
No,
See,
Lordship.
here is a case.
The question is, when you are challenging the caste, you have to belong to that caste. And for that, you need to go to the state level inquiry area for cancellation. But it is not, there is no denial that he is OBC. You don't deny that. You say that creamy layer is there. He did not, his father or mother did not form the creamy layer, and therefore so and so. Let me give you another very fine example. That is also, I thought about it on that date. For example, tomorrow the parents are there. Parents may be doing well off. But he's an OBC, but he's not being taken care of by parents, and parents have removed him or disassociated him, or he doesn't want to take the help of them. Can you just have the, because of the family, the parents here, parents' income? There are many factors which are needs to be looked at. But besides the parent, why should we issue a quo warranto? Otherwise, you'd have no locus.
If
Anyways, not to dismiss it. 4:45, miss him.
Lordship, if the OM, if I may present the OM.
OM. Regarding?
Regarding
OM or no OM? First of all, you satisfy your locus. What is your locus in respect? I would have understood. If he is in any area, have you approached anybody that he did not have the cancellation of his certificate? No, because he is OBC. Your only basic is that his father or mother had a higher income. But whether you have proved out there that he was supported by his father and mother, because you have to see at that time, he did it, he was not dependent on his father and mother at that point of time. Both of them were married.
My lord,
As per
Then
the
can you
OM,
still have that?
as per the OM Lordship, the NCL is determined by the income of the parents Lordship.
Obviously, it cannot be. Because the father and mother, he is married, he is independent. This will apply only for the students, normal students, who is dependent on the parents.
so far, my lord,
The-
locus is concerned,
But
that
Lordship,
that question is open.
one.
But when it comes to modus, my lord, on that aspect, my lord, what I can only submit is the modus of the petitioner in this case, as well as the petitioner in the earlier case that your lordship had decided today. The modus of this entire collaboration is to frustrate the school from getting prior recognition and prior permission and administrative recognition, because there is a family feud, my lord. There is a family feud. So far as the respondents number 7 and 8 are concerned, they are the daughter and son-in-law of the petitioner in today's item number 12. And this gentleman who is the petitioner herein, he is got up by the headmistress of another school, which is adjacent to this school, which segregated. Now here, the other school is now so jealous of this school.
Let's, Mr. Chakraborty, let me try my luck how the division bench will react.
My lord. I
Let us try my luck. Let's see whether my justified or not when we impose a cost of 5 lakhs to be shared by the council as well as by the petitioner.
Lordship,
50-50.
Lordship may grant me some time to.
No, 50-50 cost. But I have not, means people are thinking that I don't impose nowadays cost on I. They are thinking I have given an impression to that effect. Because I have not taken civil matters for a long time, so I don't impose normally a cost here. So let me try my luck to write a judgment of imposing a cost of 5 lakhs and make it CAV because of that, only for the cost.
Lordship may grant me some time, Lordship. I'll
For what?
convince your Lordship. I'll
No,
try
I am
to
not convinced.
I'll try to convince
I am
Lordship.
only on the question that what you are asking is, if we allow this type of writ petitions, then
people will be scared to grant admission to people, to students. They'll be scared that if we have these type of persons, this type of parents which are cantankerous in nature, and if we have their students, anytime they may go and file a writ petition. We need to protect the school also. If you have a problem with the school, very well, take your child away. Take your child away. But for that, you cannot. You don't have a locus as regard challenging his qualification. In that too in a private school. And a fraud. Cost 5 lakhs.
Lordship, it can be sometime, Lordship.
2.5 lakhs yours, 2.5 lakhs the petitioner.
Lordship, Monday, Lordship. Kindly, Lordship.
For what?
I'll try to satisfy Lordship regarding the maintenance.
Then we make it 7.5 there.
Lordship.
7.5 there. Tell your client that we impose a cost of 7.5 Monday.
Lordship.
7.5 lakhs. So then it will be 5 for you, 2.5 remains thieves.
Lordship.
Okay.
Lordship.
This court have now first, this court would hear on the local standing of the petitioner to maintain the instant writ petition. In addition to that, this court shall also consider as to whether the instant writ petition is an abuse of the process of the court in order to harass the respondents. So the learned counsel appearing on behalf of the petitioner has sought for some time. Accordingly, list this matter when you want that date or collect that money for 7.5 lakhs. When?
Any date next week, Lordship.
You have it
Lordship.
on 19th of August 2020.
Should
There is no urgency.
Art had top of the list?
No, absolutely no.
Obliged.
This court does not find the instant does not find there is any urgency in the instant proceedings. Accordingly, list this matter on 6th of January 2027.
But here, my lord, one thing I would like to submit, my lord, urgency may not be theirs, but what has happened is because of this kind of litigations, my students, 360 students of my school, their future is at stake because as I submit, my lord, as I have submitted, the prior permission and administrative recognition is
Agar order to Rakhi, we'll finish it on 19th.
deeply obliged, my lord.
Obliged, Lordship.
Yeah, please, Your Lordship.
But the money,
May I please, Lordship? Lordship, may kindly grant us some short date, Lordship. My senior is not able to attend the court due to some medical issue, Lordship.
but what has happened to PWD?
So I'm appearing on behalf of Tina for PWD, Lordship.
Fantastic. Now why? In spite of the earlier order passed and to today's order also on 3/8, when there was an assurance being given by your senior that the needful will be done, why nothing has been done?
Lordship, due to some
Or should we hold it that your senior did not apprise the PWD to do the needful?
Lordship, may kindly grant us some short date, Lordship.
Let's meet the Commissioner and Secretary PWD on the next date. But there is a specific order passed by this court. I
Should due to-
could dispose of the petition on 10/6. I know it.
Lordship.
You are going to create a trouble. That is why I kept this matter pending.
Lordship, due to health issue, maybe he gonna
Health
communicate.
issue of the Commissioner and Secretary.
No, my senior, Lordship.
Your senior is okay. Your senior, let it be there. There we have a lot of councils, standing councils of the PWD who will take care of it. Sorry. Let's see the face of the Commissioner and Secretary PWD. What he has done is, this is an atrocious order. The respondent department.
Lordship may kindly fix next week any date, Lordship. Short date.
This is the matter on Monday, 2 p.m.
Highly obliged, Lordship.
What is this? Mr. Parvez, what is this case?
May I please your lordship? And for the petitioner in item number 31,
What is the case?
it is regarding non-payment of EPFO due.
By whom? By you?
Yes,
You have not paid.
because we are
The stay.
current,
While earlier intermediary is extended, the aspect of defreezing would be considered on the next date before if it is required.
You have filed an affidavit. Yes,
Frozen.
madam.
It is complete.
readings are complete.
Frozen. Account is still frozen or not?
Yes, ma'am.
You want time.
Because we just yesterday received affidavit in opposition from
What is
respondent.
the interim order passed?
Sorry, lordship.
No coercive action to be
No
taken.
coercive action.
What is no coercive action?
With regards to the amount which has been freezed by the EPFO, my lord.
Huh?
The amount which has been freezed by the EPFO, the amount lien amount, because they were supposed to pay the amount as per 7A of the
So you have
EPFO.
freezed it. But what is no coercive action?
No coercive action of like taking money which has been kept as lien to be taken. PF.
But where is the specific direction? It's a vague order.
This order has been passed.
You use it. This money is to be paid to whom?
Money is to be paid to the EPFO, my lord.
EPF will pay to whom?
EPF will pay to the employees.
Absolutely. That is the question. So therefore, the employee should get the money. Keeping it in the hold out there is not going to help you out.
Yes.
It is at the most, you are employee.
Company. So initially, the property was with me. Then there was a deed of conveyance.
Who appears for the employees, workers, workmen?
Respondent number 5.
But I'm for the first, previous owner. of-
I am the banker.
We do one thing. It's very difficult to extend this type of it. Close eyes, when?
It's 3 weeks time, we need to file a reply to this affidavit.
The counsel appearing on behalf of the petitioner. Reply is required to be filed to the affidavit in opposition filed by the respondent numbers 2 and 3, 2 and 5.
For 5,
My lord, we have filed yesterday.
Huh?
We have filed yesterday the affidavit in reply.
Who?
Yes, respondent number 2.
Who wants to file? Against whom?
My lords, against the affidavit in opposition given by respondent number 2. The,
On number 2.
may I just make? Received it yesterday.
Huh?
We have just received it yesterday, so we need. My lords, a short date may be given. It's because there is a fees.
This matter taking into account that there is an interim order which protects the rights of the employees. It is workmen or what?
Employee Provident Fund.
You make the payment to whom?
The employees. Employees are another employer.
Taking into account that there is an interim order by which the employees are not receiving the provident fund,
Provident Fund, madam.
the dues of the provident fund. No, you don't pay it. Do you pay the provident fund daily? No.
No, once they claim, madam.
Taking into account that there is an interim order, this court fixes this matter on 18th of August 2020, 19th of August 2026. In the meantime, the affidavit be filed.
Simply obliged.
Interim order till the next. Yes, what is this matter?
Lordships, in this case, your lordships, I am the customer of the State Bank of India. Your lordships, the respondent number 4. And respondent number 4 appointed CSP center, your lordship, wherein I have opened my account and also deposit the money. But that amount was, your lordship, fraudulently taken by the centers. And when I go to the bank, your lordship, for money,
Mr. Parvez, did you get anything?
Your lordship, I have informed the bank.
Ah.
Therefore, they have engaged another account.
You?
Lordship, Mr. S. Puraguhai have been engaged in this matter.
Why, you have filed your affidavit?
Not yet, Lordship. 1 week time to file our.
Counsel appearing on behalf of the State Bank of India submits that seeks for some accommodation to file the affidavit. This matter on 28th of August 2026. In the meantime, the affidavit be filed on or before 19th of August 2026. Liberty given to the petitioner to file reply thereagainst.
Much obliged.
Mr. Parvez, your name has been shown in the cause list.
Lordship, on the last date, your lordship has engaged me. After information to the bank, they have already engaged another account.
Okay. This court appreciates the assistance which was provided by Mr. Parvez, the learned counsel. His name, his name, taking into account that there is a separate counsel being engaged for SBI, the name of Mr. A. Parvez be struck off from the cause list.
Much obliged.
The matter relates to, my lord, holding of the first meeting without serving copies of the same, my lord, from the petitioners. My lord. The meeting was held on 3/7/2025.
And what happened?
Private respondents were appointed as the president and vice president, my lord, and a copy of the written notice of the said meeting was not served upon the petitioners. My
I
lord.
was elected as the president in that meeting, but what he's not saying is that they've challenged my election as the member. So that will be direct election. Therefore, it should go to election tribunal, number one. They said I was employed, gainfully employed somewhere, and therefore I should not have been eligible for this membership, for being elected as a member. Now,
He's giving up.
if he's giving up, I'm very, very glad with
My
that.
lord,
He's
page
stating that.
19 of my prayer, my lord. My prayer is to the first meeting, my lord, where they have appointed as the president and vice president.
Then
I have
record
not-
it, Lordship.
I have not challenged his candidature, my lord.
He has. Make a specific statement.
Statement is there, my lord, that prayer is not there, my lord.
If he's banking on that,
Kindly produce my prayer, my lord. Page 19 and 20. Specific challenge is to the first meeting, my lord.
and if he's challenging my election method, it should, by section 11, it
Election,
should go
but
to
for the
the.
election.
No, election of president and vice president is outside the
Yes, my
scope of 111.
No, it's not, I'm not on that.
No, obviously, that is only election is only permissible in respect of the
Direct.
election.
Election.
Election petition, but not for others.
Yes,
That
madam.
I have also clarified in
Yes, madam.
another judgment.
Lordship is clarified in that. What I'm on is that section
But,
11 says, if he is challenging the election to the post of the president, then it should go to district commissioner.
His election is not under challenge, my lord. Page 59.
No, that I remember.
Yes, my lord. And there is already a judgment for
Well,
coordinated. with-
Page 19, paragraph prayer B, if I may just read that.
Yes.
Mandamus be not issued directing respondents to forthwith recall, resign, cancel the impugn election of the respondent number 5, I'm there, and 6, to the post of the president, vice president, so and so. If that is so, under section 11, it should go to the district commissioner.
My lord,
Petition would not
election
lie,
to the
the two
post of
ways.
President, my lord.
Mr. Counsel, whether it lies or not, why should it go to the district commissioner if he has a point of law? It's come on a point of law, and why not? Why
he's on
should he
facts.
go out there?
He's on facts.
No, the question if there was no notice being issued, which is the requirement of law as per the Assam
Very-
Constitution,
Yes, ma'am.
Panchayat Constitution laws, matter is over.
Then under that method, the district commissioner may place the stand. It's up to them.
If they don't fact, then we presume.
On 25.
Presumption
Oh,
on the
presumption.
Presumption.
The notice has been issued, presumption.
So you are the president, take it up with the district commissioner, ask them to file and file a affidavit to the effect. If you don't, we presume.
But on the last occasion, my lord,
Because of non-traverse squarely apply.
Non-paper, we have filed the
my lord,
affidavit.
on
We are not concerned with you.
25/6, my lord has specifically directed the respondents to file an affidavit, my lord. Till that, no affidavit has been filed, my lord. 25/6 order will kindly be produced. my lord.
Concern, my lord.
25/6,
Yes,
service
ma'am.
being complete, so and so, liberty.
Till that, my lord,
Pleadings
that
on of-
information is not before your lordship.
Lordship may
And in
kindly
fact,
consider.
that day I passed one judgment.
Non-traverse to that effect, it should squarely come upon me for the reason, number one, because
concerned.
all the other persons have served, they take up a plea, and absolutely omnibus plea, we are not served, nothing on that. District commissioner being silent, we elected person, a democratically elected person, but because of the silence of the district commissioner, I cannot demit my office on that count, Lordship kindly consider,
No way out.
Rule
I
has
can't
not
help
been
it.
followed, my lord.
This is something which I cannot even file of affidavit. We have filed an affidavit,
No, the law is law. Law says that every member has to be provided with a notice. There's a specific requirement as per 46.
46 is there.
The manner is prescribed, my
Very
lord.
well,
Manner
Milord.
is prescribed, that has to be followed, my lord.
For a moment, your Lordship bears with me, for a moment,
No.
So far as I am concerned,
Apart from
he's
the-
also.
fully law, my lord.
Mister, we don't set aside other thing. We only set aside the first meeting.
Yes, my lord.
And ask them to have another meeting, but not today.
By
Today
issuing
is too
notice-
late in the day on a Friday to do so.
Lordship, I'm obliged.
Next week, my lord, Monday, my lord, at 2, my lord.
Not Monday.
Matter is
Anyway,
already covered, my lord. Next week, my lord.
That day I passed one judgment of one. I forgot whose name it was recently. I passed one order on. You asked Mr. Dotto, he was there.
Yes, my lord, definitely.
Okay. Taking into account, the district, you have not filed it. Okay, you produce the records on the
Grateful,
date.
my lord.
The the district commissioner, which place?
Mankasar, my lord. South Salmara, Mankasar.
South Salmara, Mankasar have not filed the affidavit in spite of various opportunities. Mr. J. Hendik, who appears on behalf of the state district commissioner, shall obtain the records of the first meeting of which Gram Panchayat? Which Gram Panchayat?
Number 19,
Number
Kothal,
19,
Kothalbari Gaon Panchayat.
Kothalbari Gram Panchayat
Block 2.
on the next date. Full stop. Taking into account the above, list this matter on 20 and then 25th of August 2026 at 2 p.m.
I'm very grateful, my lord. Obliged. Grateful, Lordship.
The lordship, the affidavit filed. May I please beg for a date anytime after a week?
An affidavit has been filed with respondents and the petitioner would like to file reply. List this matter again on
KG Chaudhary,
9th of September.
deeply obliged to lordship.
Be filed.
May I please, Lordship? This matter pertains to illegal construction of sanitary tank and
What matter is this?
that JMC has to take instruction regarding assessment,
It is
etc. matter.
Assessment of the
Which have been assessed.
the petitioner.
You got to extract of the assessment order.
1976, 77 assessment of order of the respondents are having, I've got the extracts of the all this. That will make it clear, my lord.
Here the pleadings are complete.
No,
No, no,
Huh?
this,
reading.
Affidavit filed by the private respondents. And GMC is not going to file.
you can see it's not going to file, my lord. No.
Huh?
That
No,
is
you have
after-
not filed it.
Not filed, but that particular lordship were directed to bring the assessment list that has come.
Order detail.
Until post week,
By the
after 2 weeks, my lord, if required, I'll file my affidavit. I'll bring this assessment list.
So you have got that extract. So with that only we can finish it off.
That can only can finish it up, my lord.
Because it will make it clear, my lord, assessment of that particular respondent of 1976, 76, 76, 77.
There's no requirement on the basis, there's no requirement of any affidavit from your side?
The lawsuit will post it, if required, I will go through it once again, my done.
I'll post it after that because this is against a certain order. But if it is not required, not necessary. If you can produce the records and because, or if you can rely upon the pleadings of either of the parties, if you want to do it, you can do it. So we post it on some other day because on many occasions the matters have been coming every time I list the matter, this is being done. Okay. It has been submitted that on the basis of the pleadings which as well as the records, as well as the other documents which are available on record, the instant proceedings can be disposed of. Mr. Espora, the learned standing counsel of the GMC, shall produce the records which led to the passing of the impugned order.
When extract of the assessment.
Some impugned order is passed,
Yes,
na?
my lord. Yes.
Records of the demand along with the extract of the assessment register of the building
Yes, I have.
has been assessed to the GMC.
I have
My
the
lord,
the next date.
my lord, actually 1987, my lord, the GMC had issued a notice to
No, we are only concerned with that order of 25.
Yes, my lord.
The records of the or impugned order of dated 25 2025 and the extracts. Okay. We have it this matter for final disposal on 15th of September 2026.
I am submitting that only because that assessment is prior to that, my lord. Prior to
I'm not
87.
concerned with other documents. We are only concerned with, I've asked him to, there is already an assessment extract I've asked him. So that I have already mentioned. And the other is that in the records of this order, the other pleadings are there.
Yes, my lord. That is correct, my lord. Obliged, my lord.
Yes, Mr. Praguha.
May it please, your lordship.
What is this?
In terms of the order which was passed on the last occasion, my lords wanted me.
Ah,
to
this
instruct-
one.
Yes, my lord. I had a telephonic conversation with my client as she is, my lord, out of station. And from the perusal of the
Obviously, therefore you have the telephonic conversation. Yes. How does it how is it important? Obviously, you are whether out of station. I've not asked you
No,
to.
no, my lord, I'm
You have to obtain instructions.
what I have learned, my lord, and also from the perusal of their instructions, my lord, one thing, my lord, they have noted in the instructions, government, my lord, when they have requisitioned the land and they have basically not gone ahead with the acquisition process, the acquisition process is now stalled for the, as the case is pending, my lord. There's one aspect. The second aspect, my lord, they have noted that they have done a joint survey, and in the joint survey, they have seen that the road, which is the current road which we are using for ingress and egress, my lord, they are going to leave a road around, my lord, of width of 16 feet and above, my lord, 16.50 feet. Although my current width is, my lord, 10 feet. So they are saying in this instruction that they will leave around 16 feet. My lord, even then, my lord, in the last occasion, I brought an affidavit, which is on record today, my lord, where we said that the fire norms and, my lord, the conditions which are required to be followed when a new construction is done, my lord, a minimum requirement is.
You got the permission for the new construction.
No, my lord, we have got the permission for the new construction. Permission has been given by GMDA. We have got the permission. Only the fire norms we have applied. And
No. My question is,
My lord.
you got a approved plan. So with that, it has given this particular.
Yes, the width that we have given is beyond 10 feet. That is the current we are
So
using.
these are the questions which the authority can look into it. Why should we look into it?
No, my only my
Isn't it,
apprehension.
Mr. Nayak?
My only apprehension.
Can I look into this? What is going to happen? What not? If you have any difficulties, you see the moment the requisition is being done, there's a form 3. The objection is being sought for. You can very well submit an objection.
No, my difficulty is my beg to pardon. I beg your pardon, my lord. The requisition process has already been over. Acquisition is
Understood, but thereafter they will issue that notice, na?
for under.
Go and object to all these things. I'll grant you the liberty. That is what I'm not going to decide where it is happening and all.
Only
Is it possible for us? No.
If I'm not,
Even on the administrative side, yesterday I was mentioning that even on the administrative side, we are not in the position to say where the construction should be. And now you want on my judicial side that I should say where the footbridge should fall. I can only say one thing, Mr. Nayak, that the footbridge should fall in such an area which is does not in any manner narrows down the main road.
I hope Lordship that will not be designated.
No, that should not, because otherwise, in many places, because you see, the moment the footbridges are there here in Assam, in Gauhati, we are all having with escalators and all. Now, with these escalators which are there, it takes a sizable area, and because of the sizable area, it is encroaching on the road, and by that, you have these problems in GS Road and also in that particular.
Creates a bottleneck.
But it creates a bottleneck. Once the bottleneck is there, it becomes a difficulty. But anyways, we'll have it on some other day. When?
I have received some instruction, Lordship, but he has submitted, Lordship. Let me have instruction on that point also, Lordship. Lordship will take up after 2 weeks, Lordship.
Okay. Because the only problem is you have not gone for further acquisition only because of the pendency. That is why I'm saying this. That is why I kept the matter today, because of the fact that this was on 31/7. I kept it today so that the matter could be done fast, because of the court there should not be a stalling of a public area. You tell me when you can do it, because then only the thing.
Lordship will take up this matter on 18th, Lordship.
It is too far off, no? Don't you think?
And on 25th, Lordship.
No. Isn't it too far off?
October.
I'm not on that. You want very well, I can have it.
Just 1 week only, Lordship. Today is 7th, Lordship.
So let it be on 24th. Okay. This is the matter on 24th of the year, on which date Mr. Pinay shall obtain instructions as have been in respect to the submissions so made by Mr. H. Buragoy, the learned counsel appearing on behalf of the petitioner. You have anything?
So, my lord, my lord, may I submit? An additional affidavit has been filed. So perhaps my learned friend would like to give it.
Received copy.
No.
No, replies not necessary. We don't go well, because the moment they keep on replying, then the scope of the proceedings before the collector gets reduced. They get bound out there.
Very well, my lord. I'm obliged, my lord.
So in this case, our affidavit is ready, Lordship. We will file our affidavit by Monday. We
Then-
are appearing for response 5, 6, and 7.
Okay, counsels appearing on behalf of the respondents.
5, 6, and 7. Lordship.
For how much time?
We'll file it by Monday, Lordship. Affidavit.
Interim?
I have also received the instruction.
No interim is there.
No interviews.
No interview.
Okay, the affidavit would be filed within by Monday. And yours?
Lordship, I have received the instruction on affidavit of this. I have to prepare.
Submits that the list is matter again on 19th of August 2026. In the meantime, the affidavits be filed by all the respondents.
Deeply blessed.
It does.
Please, Lordship. My lord, I'm yet to file my affidavit, my lord. Is there protection given to the petitioner?
Oh, yes. ERB sleep.
Here we sleep.
Then what happens?
Then, my lord, we have abided by your lordship's interim directions. We have abided by your lordship's interim directions. No further deduction have been taken place. Now, my senior friend, my lord, has filed an additional affidavit, bringing on record certain subsequent developments, my lord. Fact that the ERV slips did not correspond to the show cause.
No, what has happened to the so-called proceedings?
No, the show cause.
The hearing is done.
My lord, hearing has been done and the reply has also been given, my lord. The reply is on page 1.
I'll fix a date for giving a personal hearing.
My lord.
In the next, no further deduction be. I further observed that all deductions which have been carried out till they shall be subject to the outcome. Then we do a more hearing done.
No, my lord, that I do not have instructions on. The
Obtain
reply,
that
the
instruction.
reply is on page 100.
We have filed our
No, you let us obtain the instruction on
Fine.
Monday or Tuesday, Wednesday. You obtain the instruction, hearing done or not.
All right,
Then I give you the liberty to pass the order.
my lord.
Once you pass the order, after the hearing, then we could, but keep the order subject to outcome.
My lord, my lord.
Then
my
the
lord,
proceedings will
my lord,
happen.
my
now.
lord.
We do one thing.
We have filed our additional affidavit to that, my lord, day before yesterday, my lord.
Regarding
Regarding my lord, subsequent development, we have filed our, my lord, reply to, and some documents.
hearing done or not?
By my instruction, my lord, they have provided the ERVs, my lord.
Have the hearing been done or not?
Our hearing was not done, my lord.
What proper hearing? Hearing was done or not? There is no proper hearing. You may always require tomorrow. You will always any counsel whose writ petition gets dismissed. He always goes outside and says, "This judge did not give me a proper hearing." I'm not on that. I'm saying hearing done or not.
So they have provided the ERV slip, my lord, and a meeting was held, and the minute has been provided to us, my lord.
Hearing done.
Yes, my lord. And that was, my lord, on record, my lord. We have filed our affidavit, my lord.
It has been submitted at the bar that in pursuance to the order dated 10/6/2026, the so passed at paragraph number 12 have been duly complied with, and in the meantime the hearing have also been completed. This court fixes this matter on 21st of August 2026.
To humility.
You are not there.
I'll be there. With
On
regarding-
24th,
My lord, date is not the issue. My lord, the hearing, whether it has taken place or not, my lord, because the minutes which have been submitted by my senior.
because I directed them to complete the hearing by 31/7.
I'll just take instructions on that count, my lord. Will fix it on Tuesday at 2 o'clock, my lord. I'll just give, I'll apprise this court, my lord. That is only my submission, my lord, because
Okay.
the minutes which have been given at page 98 is regarding submission of the ERV slips.
Okay.
We have not deducted any further amount.
It is. This court inquired with the counsels appearing on behalf of the parties as to whether the personal hearing which was directed to be completed on or before 31/7/2026
My
have been completed or not.
My lord, only on that front. my lord.
Mr. M. Sharma, the learned counsel appearing on behalf of the respondents, submit that he will obtain instructions in that regard. List this matter again on 14th of August 2026.
Since it's for instructions, it can be on Monday itself, my lord. I can get the instructions as soon as possible, my lord. I'll not trouble this court for a longer while, my lord.
Health.
I'm grateful, my lord. Please.
Wait, please, your lordship. Lordship, we appear before the respondent number 5, your lordship. We have submitted our documents, your lordship, but they are yet to take any call regarding it.
Consider the request. You submitted the documents.
Yes, your lordship.
What happened? No order passed.
Lordship, whether the order was been passed on about that instruction, I have to take. Lord.
Mr. J. Hendrik, the learned counsel appearing on behalf of the district commissioner, district administration shall obtain instructions as to what transpired pursuant to the order, pursuant to the directions passed by this court in the order dated 25/6/2026. This matter on 19th of August 2026. Is there any interim order?
No, no. So only while that notice was issued on 9/6, Lordship, he was asked to my lord submit some documents, Lord.
Lordship, only it was true.
Okay. Last neck.
Yes, this matter, Lordship. We have disposed of their application, Lordship. We have disposed of their petition, Lordship. Representation.
Directing the respondents to consider and pass orders in a representation which may be filed by RIA.
We have considered that.
Dispose it off.
I've given the copy, Lordship.
Okay, we then finish it off on another date. The council is not there.
Lordship.
List the matter on Wednesday. Mr. P. Sharma appears on behalf of the Fishery Department,
AFDC.
AFDC, and submits that the representations so far submitted by the petitioner have already been disposed of. The copy of the said order be placed before this court on the next day.